잠시 안내 말씀드리겠습니다. 잠시 후 10시 30분부터 컨퍼런스가 시작될 예정이오니 내일 기빈께서는 행사장 안으로 입장해 주시길 부탁드립니다. 감사합니다. Good morning, ladies and gentlemen. May I have your attention, please? Today's conference will begin at 10:30 a.m. So please come into the conference room and take your seats. Thank you for your kind cooperation. 네, 기빈 여러분, 컨퍼런스가 곧 시작될 예정입니다. 행사장 밖에 계신 분들은 행사장 안으로 조속히 입장해 주시기를 부탁드립니다. 감사합니다. Distinguished guests, today's conference will begin shortly. For those who are outside the conference room, please enter the conference room and take your seats. Thank you for your kind cooperation. 오늘 컨퍼런스에서는 참가자분들의 편의를 위해 동시통역 서비스가 제공될 예정입니다. 행사장 입구에 비치된 동시통역기를 착용하시고 편하신 언어를 선택해 주시길 바랍니다. 한국어는 채널 1번, 영어는 채널 2번입니다. And simultaneous interpretation service will be provided for the conference. So please take your receivers, which is available at the front desk, and choose your preferable language. Channel 1 is Korean and Channel 2 is English. 아울러 행사의 원활한 진행을 위해 행사 중에는 소지하고 계신 휴대전화의 전원을 꺼주시거나 진동 모드로 바꿔주시길 바랍니다. It would be greatly appreciated if you could turn off your cell phones or put them on silent mode during the whole conference. 또한 코로나 확산 방지를 위해 행사 중에는 마스크 착용을 부탁드립니다. And to prevent the spread of COVID-19, we would like to ask you to wear a face mask during the whole conference. Thank you for your cooperation.
(1948년 12월 10일) 유엔 총회는 세계 인권 선언을 채택하며 인권의 날을 지정하였습니다. 인권은 모든 사람이 차별 없이 누리는 보편적인 권리이며 모든 국가는 인권을 보장할 책무를 지니고 있습니다. 국경을 넘어 세계적인 과제인 인권 보장 및 증진. 노동인권도 예외가 될 수 없습니다. 노동자 및 사용자는 어떠한 차별도 없이 사전 인가를 받지 않고 스스로 선택하여 단체를 설립하고 해당 단체의 규칙만을 따를 것을 조건으로 하여 그 단체에 가입할 수 있는 권리를 가진다. 국제노동기구 결사의 자유 및 단결권 보호에 관한 협약 제2조. 2022년 4월 20일 국제노동기구 기본협약인 제87호 결사의 자유 및 단결권 보호 협약과 제98호 단결권 및 단체 교섭권 협약이 대한민국에서도 효력을 갖게 되었습니다. 국제노동기구 협약 발효 후 법원의 재판에서 무엇이 새로운 쟁점이 될까요? 사법정책연구원은 현실과 규범, 실무와 이론을 아우르는 체계적인 연구를 통해 미래의 사법부가 추구해야 할 바람직한 모습을 만들어가고 있습니다. 2022년 사법정책연구원은 국제노동기구와 유엔 인권 최고대표 사무소와 함께 국제인권법 및 노동법 전문가들을 모시고 국제노동기준 및 국제인권법 적용에 관한 쟁점과 과제를 고민합니다. 인간으로서 가지는 보편적 권리, 인권. 모든 노동자가 누려야 할 인권, 노동권. 이제 새로운 모색을 향해 출발합니다.
Good morning, distinguished guests. Welcome to the second day of 2022 JPRI International Conference. I'm Dr. Hyojung Kim, a professional researcher of JPRI. It is a great honor and privilege for me to be a master of this conference. I hope everyone has slept tight last night and ready to participate in inspiring sessions today. Under the theme of international labor rights as human rights challenge for judiciary, today we'll address ratification and domestic implementation of the ILO Fundamental Conventions. Last year, Korea ratified the ILO Fundamental Conventions, which protects freedom of association and the right to organize and bargain collectively. And these conventions came into effect in April of this year and had the effect of domestic law of Korea. Against this backdrop, I'm sure that today's discussion will provide precious implications for Korean judiciary in interpreting and applying the ILO Fundamental Conventions. On behalf of the organizers of the conference, I would like to express my heartfelt gratitude to all of our distinguished guests for taking time out of their busy schedules to join us. I would like to welcome who are joining us over YouTube as well. We are broadcasting the entire conference live on Judicial Policy Research Institute channel on YouTube for the people who could not attend at this venue in person. As with yesterday, we'll provide simultaneous interpretation service for the convenience of multinational participants. Please take your receivers and select channel 1 for Korean and channel 2 for English. Without further ado, let us begin session 3. Moderators, speakers, and panelists of session 3, please come up to the stage and be seated in your designated seats. Before commencing session 3, I would like to inform you how to ask questions to the speakers. You could ask questions through leaving your messages on YouTube comment section. If you have any questions for the speakers, please feel free to leave your messages. And we're running a real-time viewing certification event. For detailed information on how to apply for the event, please refer to the information on the More from YouTube section. Our topic for the session 3 is ILO Fundamental Conventions, Importance and Implementation. It is a great honor for me to introduce the moderator of this session. The moderator of this session is Mr. Ji-hyung Kim, the former Justice of Supreme Court of Korea. He is currently a managing partner of Gpyeong LLC and a founder of Korea's labor law think tank Hamel Institute, sponsored by the forum. After serving in the judiciary as a judge for 21 years, he was appointed as a justice of Supreme Court in 2005 and made the most pivotal decisions on labor law of Korea. As one of the leading practitioners and scholars in the field of labor law, he has been writing extensively on the labor law issues, including the most authoritative commentary on the Korea's labor law. Ladies and gentlemen, please join me in welcoming him with a big round of applause. Mr. Kim, now the floor is yours.
예, 반갑습니다.
Good morning, ladies and gentlemen. I have the honor of serving as a moderator in this session 3. My name is Ji-hyung Kim. Now, I would like to first thank the organizers, especially the Judicial Policy Research Institute, for organizing such an excellent conference. And I would also like to thank all the participants, both offline and online. Thank you so much for your time. Now, it has been introduced already, but this conference is about international human rights and international labor standards, and in particular, challenges for the judiciary. So what are the challenges and tasks placed upon the judiciary as far as my understanding goes? Now, in that context, this session 3 is about the ILO Fundamental Conventions, and we will be discussing the implications with regards to the labor laws of Korea. Now, the ILO, as we all know, was established after one of the most atrocious events in human history, after the World War I. So it was established in 1919, and it has gone over its centennial anniversary. And the ILO, since then, has produced around 190 conventions. Of them, I understand that the fundamental conventions are 10. Of them, Korea has ratified 3 fundamental conventions, including the one on freedom of association in 2021, last year. And then 1 year later, in April this year, they went into effect. And now, more than anything, for these fundamental conventions, what do they say? And I would say that what has to precede all else is to have an understanding of the provisions of their content. And the fact that the conventions have gone into effect means that now they have the effectiveness of domestic laws in Korea. And then now, when it comes to the implementation of the conventions, we are now subject to the supervision of the ILO. Now, against this backdrop, for the courts, in their running of the trials, and also as we subject ourselves to the ILO supervision, there could be a number of legal issues to arise, and I believe that this will be the time for us to go over such potential issues. Now, in this session, regarding these particular questions and issues, we will be hearing from the speakers and panelists from home and abroad, and I'm sure that we can look forward to their tremendous insights and expertise. And now, allow me to have the opportunity to introduce the experts on stage here with me. Now, first, among the two speakers is Karen Curtis. Now, Ms. Karen Curtis is a graduate of the University of Minnesota Law School and majored in philosophy at Barnard College. And she joined the ILO Standards Department in 1988 and was appointed Deputy Director of the International Labor Standards Department in 2005. And since 2012 holds the position of Chief of the Freedom of Association Branch. So please welcome Ms. Karen Curtis with a big round of applause. Yes, welcome. And the second speaker in this session is Professor Eun-jung Park of the Law Department of Inje University. Professor Park lectures in anti-discrimination legislation, labor legislation, and social security legislation. And as the main research field is untypical employment, Professor Park has also published many articles. And she also had been a member representing public interest in the Social and Economic, Social and Labor Council of Korea. So here is Professor Park. Thank you. And then now let me introduce the panelists. First is Judge Young-jin Kim. Judge Kim has served in courts at various levels since his appointment in 2009. And currently, he is a judge in the Seoul High Court. So here is Judge Young-jin Kim serving as the panelist today. And we are expecting another panelist today, and since he is traveling from out of town, he will be arriving in a while. So as soon as he arrives, then I would introduce him at the panel discussion time. And with that, we will now begin session 3. Now, the job of a moderator, of course, is to manage time. Since we have only limited time given to us, I would like to ask for your cooperation so that I can do my job as a timekeeper. So now then, the first speaker is Ms. Karen Curtis, and she will talk about the Republic of Korea and the ILO for 30 minutes. Please go ahead.
Thank you so much, Judge Kim. It's an honor to be here on this panel with you this morning. And I want to also very much thank JPRI for having this excellent initiative to really bring knowledge of international labor standards throughout Korea to Korean judges and lawyers. First of all, unfortunately, and my apologies, the presentation that is in the book is actually not the correct presentation. So you will not be seeing the same thing on the screens. I will be talking about the fundamental conventions as the session has indicated, focusing on their importance and implementation. All day, I think we will have a lot of detailed discussion about the implementation of international labor standards with quite a focus on freedom of association. But today, I want this morning very much to focus on why it matters to the judiciary that there are international labor standards, that there are fundamental principles and rights at work, and why it matters even beyond the insular scheme of the ILO and its ratification, its very important international commitments, but that this has also expanded with a globalized world. It's expanded to being an important element in trade, commerce, the economy. So it's not simply a question of labor law, but also a matter for the Korean government in terms of its trade relations. So I will also speak a bit to how trade is promoting international labor standards and how in the framework of the EU-Korea free trade agreement, how trade has also shown itself to be almost a parallel supervision of international labor standards, and what impact that can or may have for the judiciary. And finally, I will just at the end speak to some progressive judgments that have shown how Korean judges have used or been inspired, even if they haven't specifically referenced international labor standards. But the same spirit has embodied some Supreme Court judgments. So you all know very well about the history of the ILO. I don't necessarily need to focus on that, but I did want to mention that it's rather interesting that the fundamental conventions were not the first conventions ratified by Korea when it became a member state of the ILO. The first conventions were the Labor Inspection Convention, a very important convention in terms of ensuring the enforcement of labor rights throughout the world of work, and the Employment Policy Convention. So the focus was less on fundamental rights and more on employment, ensuring that all workers were in full and productive and freely chosen employment. Ratification matters. We have many fundamental principles and rights at work, and in Korea for quite some time, what were then 4 of the 8 fundamental conventions had not been ratified. But ratification matters, of course, to the judiciary, and it was mentioned by Judge Kim. Now you have the conventions, the 3 recently ratified fundamental conventions coming into force. Also provides a framework for the judiciary to look at the application of its laws within that context. But it matters also from the government, from the executive perspective, in that it's a voluntary commitment to not only these standards, these minimum standards, but also to accept international supervision, which means that they engage in that process with the ILO, and they accept that there will be comments from a committee of experts that you heard about yesterday that will be looking at how the convention is being applied in law and practice and where there may be some gaps. So that process, yesterday one of my colleagues was asked, well, are the committee of experts' comments important? They are important in the guidance as to what these broad principles in those standards mean, and they are important because they have been along for a long time, this review of the application and the jurisprudence, if we can call it that, that has come out of the supervisory bodies. It's also important because when we're talking about labor law, it's not, again, simply a legal review, but one that takes into account the perspectives of business and labor, because they have a word not only in the elaboration of these standards, but they have a voice in saying how these standards are being applied or not being applied in any given country. And the supervisory system of the ILO also provides, however, guidance for good practice and can inspire the judiciary, not only looking at how Korea is seen as applying a specific convention, but other countries, how they are applying, how they have found solutions to gaps in compliance of international labor standards. So we can see that in terms of the universal acceptance of the fundamental principles and rights at work, we are quite close in the ILO for most of the conventions. You can see that Convention 182 has actually had all 187 member states of the ILO have ratified it. And then many of the other conventions are quite close, just a few ratifications away from showing that the entire international community commits to these standards, believes that they are the fundamental rights that should be respected. Now you have, towards the end of this list, you have the more recently identified as fundamental rights. And I'm sorry that the graph doesn't show for each one, but where you see 75 ratifications, that's Convention 155, Occupational Safety and Health, already ratified by Korea before it was identified as a fundamental convention. And at the next, you have 57, that's Convention 187 on the Occupational Safety and Health Framework Convention, again ratified by Korea ahead of this identification as a fundamental right. And then finally you have the Protocol to the Forced Labor Convention 29. These have lower ratifications, but we expect that this will come up quite quickly in terms of showing the universal commitment to these conventions. Now you also see what is going to be much of the discussion today. On the left side, 157 ratifications is Convention 87 on freedom of association. 168 is Convention 98 on collective bargaining. Those are slightly lower. They're still quite high in ratification, but they're slightly lower in terms of the other fundamental conventions, and this has very much to do also with the challenges that maybe you see also in Korea, and we will be talking about today in terms of applying fundamental principles of freedom of association. To look at the the regional ratification rate, if we look at Asia and the Pacific, I wanted to just highlight this because Convention 105, which is the only fundamental convention not ratified by Korea, it is only 9 ratifications away from full universal acceptance, and they are all in the Asian region. All other regions have ratified Convention 105 on the abolition of forced labor. It's something that I'll come back to because I think it's a very important convention that also should be promoted towards its application and ultimately towards its ratification. So these fundamental conventions and their ratification and their implementation ensure a level playing field. This is why the ILO was created, was to avoid that there would be a race to the bottom, to ensure that all countries could be competing, even, and this is why I will come to the trade question as well, competing, but with respect for the same labor standards. Korea's ratification, particularly I think of the freedom of association and collective bargaining conventions, was particularly important as a leadership statement of the importance of democracy, inclusive participation at the workplace. And Korea has taken that lead in the Asian region, which has many, many more ratifications to achieve for these two fundamental conventions. As I mentioned before, that the supervisory bodies will provide the benchmarks, but those benchmarks then enable the identification of progress. How are we coming closer to the elimination of child labor, the abolition of forced labor, but also the achievement of freedom of association? And all of these are taken up in the Sustainable Development Goals. So it's not just an issue for labor, but something that's seen across the UN system as being critical to sustainable development under the particularly the Decent Work Sustainable Development Goal 8. And there I must say that we see an alliance for the elimination of forced labor, but we also have under Goal 8 an indicator which identifies gaps and progress in promoting freedom of association around the world. And that indicator is a quantitative indicator. It uses the ILO jurisprudence, the ILO sources from the Committee of Experts, from the Committee on Freedom of Association, to identify where there are still issues that need to be resolved in a country, and to then show when they are resolved that there is progress through a quantitative indicator. This is something that is done through the UN system, and there will be a dashboard soon on the ILO website which will show this. But then I wanted to focus a bit on how trade has really promoted fundamental principles and rights at work. For the EU-Korea Free Trade Agreement, it's done that in the Trade and Sustainable Development chapters, and I'll speak a few moments also to the expert panel review of that. And finally, the fundamental principles and rights at work are really essential as an objective for socially responsible business. So business has a duty as well to be ensuring that it's playing its role to respect and promote the fundamental principles and rights at work. And so you have this in many different international instruments, the OECD guidelines, business and human rights guidance, the multinational enterprises of the ILO declaration. But business in Korea will be seeing this as an important element in the future because the European Union is in the process of adopting a due diligence directive, which will mean that all European enterprises will have to ensure that down their value chain, including what they get from Korean enterprise, that they have looked at the fundamental principles and rights at work and that they have done their due diligence to ensure that there is respect for that. And there is another element which will be also very important to Korean business, which is the forced labor products ban. So the European Union is in the process of adopting a regulation which will mean that should there be any forced labor in the production of products being imported into the European Union, that they will be banned. So it will be very important for enterprises to be able to show in Korea that they are ensuring there is no forced labor. And when we come to the question of Convention 105, abolition of forced labor, which can mean also prison labor, it will be very important to know that there is no prison labor that may give rise to a product that could be exported to the European Union. So I don't need to go over the supervisory system, you know it very well. Judge Kim mentioned you now have these three important conventions: freedom of association, collective bargaining, elimination of forced labor, now are in force in Korea. and Korea will have to report to the supervisory body, to the committee of experts. They will have to report on how these conventions are applied, not only in law, but also in practice. Here, the judicial decisions will be very important for Korea to be able to show how they are really effectively being applied. The information that will come to the ILO supervisory bodies will also come from business and labor. So the first comments of the Committee of Experts will be published in 2024. So first reports by next September, and then examination, analysis, and first comments. I'm sure that many of the judges know that there have been cases traditionally brought to the Committee on Freedom of Association. Now, the extraordinary thing, of course, about the Committee on Freedom of Association is that it is a unique body that can examine complaints even without ratification of the conventions, which meant that as from Korea becoming a member state, 1 year later, the first complaint came to the Committee on Freedom of Association, which helped pave the way towards the possibility of ratifying the convention just a year and a half ago. Because all of those cases before the Committee on Freedom of Association gave the guidance, the recommendations to the government of Korea to gradually develop an industrial relations system that was more and more in line with freedom of association. That committee will usually send legislative aspects now that the conventions have been ratified. That committee will send the legislative aspects to the Committee of Experts to continue its examination. The other thing that's important about ratification is that the observations of the Committee of Experts can be brought before the Committee on the Application of Standards. And that means that potentially, and Korea already has been on other conventions, but can be brought before an international tripartite public forum to discuss the issues and the challenges that it has and to hear the recommendations that might be made. But I also wanted to point out that we have attending quite often the Committee on the Application of Standards, judges, the judiciary from various countries, because they come to hear the kinds of challenges that might arise in the application of these conventions in other countries, to be able to learn from the dialogue and the discussion that takes place at this international conference. So I wanted to mention, as I said, how trade has also been able to promote fundamental conventions and to promote their implementation. It has been an important impetus, and particularly with the dispute and the possibility of a panel of experts to actually look at the issues and then see whether progress has been made. And here you have a link between, on the one hand, the identification of issues by the panel of experts, and on the other hand, the EU looking to see whether progress has been made, but looking to the ILO supervisory bodies. So the trade and the international labor standards link, and even the supervisory bodies of the ILO is quite demonstrative there. So it's an opportunity. I think it's really an opportunity to promote fundamental principles and rights at work through trade agreements. It's a two-way street. It's not just Korea, it's also the European Union, which has responsibilities in this particular case, and also in other trade agreements. It's not a question, as might be raised and had been raised by the government of Korea when it defended itself before the expert panel. It's not a question of protectionism, Again, as I stated at the outset, it's actually the reason for the ILO, which is to create that level playing field, which means that the minimum standards, particularly in these fundamental rights, should be respected throughout the globe. It's not either a question of harmonization of labor standards. It's not an issue of, and particularly the ILO conventions don't say that Korea has to adapt the same industrial relations system as might exist in Europe or might exist in the United States, but it has to be based on the same bedrock of fundamental principles. And there you can look at the compilation of the Committee on Freedom of Association, its decisions, which has been translated into Korean. So I'm very happy to know that it is possible to disseminate throughout the judiciary very important decisions that have been taken by the Committee on Freedom of Association. So it's also not contrary to the economy to abide by, promote, and respect fundamental principles and rights, international labor standards, ILO conventions. When we look at the OECD countries, and congratulations to Korea, because you're in the red, you're only one ratification away from full ratification of the fundamental conventions. Almost all of the OECD countries have shown that in the first 8 basic conventions, before the occupational safety and health conventions were added, that it was not contrary to economic development to abide by those basic principles. And now Korea itself is an example of that. So if we look at the report of the panel of experts, we can see this is within the framework of the trade agreement. The question that I might pose here is whether we have a parallel examination of ILO conventions. In the ILO, we have the Committee of Experts that you've heard about, we have the Committee on Freedom of Association, but now we have a panel of experts that has a dispute which says that certain elements of Korean law do not apply ILO conventions. So we have another group of 3 people, a panel of experts, one identified by Korea, one EU, and one joint. Fortunately for the ILO, the panel of experts turned to the compilation of decisions by the Committee on Freedom of Association to look at what kind of cases were seen to be in non-compliance. And so on that basis, they could make their decisions. It's quite interesting that they took the compilation of general decisions that concern many countries, and they didn't take the cases that had been brought against Korea in the Committee on Freedom of Association, because the same things were raised directly to Korea in complaints made by the Korean trade unions. But had they done that, they would have been accused of turning non-binding recommendations of the Committee on Freedom of Association into binding law. So they said, okay, we won't, we'll go to the bedrock, we'll go to the foundation, this is the compilation of decisions, this will be our guidance. And fortunately, they made the same decisions that the ILO Committee of Experts, the ILO Committee on Freedom of Association had made. Beyond that, there remains the question of ratification. In the trade agreement, there is a commitment, and interestingly, a commitment for continued and sustained efforts to ratify the fundamental conventions. The expert panel said that that is a binding commitment, not legally enforceable, but a binding commitment, meaning that Korea has to make these continued and sustained efforts. There was a different idea about what continued and sustained efforts mean. So here we're back into interpretation now of trade agreements. Korea said it means not going backwards, and the EU says it means diligently going forwards. But both agreed that there need to be persistent efforts. So that means that with the remaining convention on the abolition of forced labor, it's important to continue to move forward. This will be something that, within the framework of the trade agreement, will continue to be followed up by EU and Korea. This is important in terms of the global context in Korea, how Korea sees what its commitments are as a government. It may need to take legislative change, but the judiciary can potentially also provide guidance where legislation might enable an opening of understanding, and we will see later some of those issues. I would maybe point out in particular the question of the obstruction of business clause. Briefly, just to talk about forced labor, because that remains one of the non-ratified conventions. Of course, very important that the basic Forced Labor Convention 29 was ratified. There are quite a number of people in the world, according to the recent forced labor estimates of the ILO. But more importantly is that work still needs to be done for the abolition of forced labor convention. And here I mentioned the question of prison labor for strike action, thank you, prison labor for political dissent, political opinion. These issues are complex to tackle, that the Korean government has indicated that they are difficult to tackle. I understand that imprisonment with forced labor is the norm. It's what usually happens. It's rare that you don't have labor when you go to prison. Where the judiciary can help in this space is to ensure that the section where you have to impose a penal sanction, to ensure that if it has to do with the expression of political opinion or with the exercise of the right to strike, that the section of the criminal code is used that sends to prison, but not just simple detention without labor. Finishing up just on freedom of association, because I know that will be most of the discussion for the rest of the day. Of course, we know freedom of association is a human right. The fundamental rights, labor rights are human rights. But it's also the key to sound and equitable relations at work. So it's not, I heard, I think, earlier about the importance of having a balance between business and labor. That's what freedom of association and collective bargaining actually propose. It is also not a deficit to the economy. To the contrary, it is something that actually enables inclusive economic growth and poverty reduction, a fairer income distribution, and there we'll see the importance of collective bargaining. It also promotes a peaceful and inclusive society. The idea of repression of trade union rights being the way of ensuring that the society is peaceful has actually been seen empirically not to be correct. Those are the basic rights, you know them very well. The right to form and join an organization of your own choosing, the right of those organizations to exercise their activities freely, including the right to strike, and to engage in collective bargaining. And I just wanted to say that on collective bargaining, that's where we see that actually collective bargaining is an important reducer of income disparity and inequality. So the importance of looking at how collective bargaining can be expanded to cover more workers, which may mean going beyond, of course, also enterprise-level collective bargaining. And finally, the Committee on Freedom of Association cases, which I mentioned before, important progress has been made over the years for Korea, and that should not be denied. And in particular, I wanted to welcome very strongly the decision of the Supreme Court on the migrant labor unions. This decision was actually, it followed in terms of time the position of the Committee on Freedom of Association, which had said that all workers, including irregular migrant workers, including those that don't necessarily have the right to be in the territory and work, but if they are a worker, they must be able to organize and to defend their interests. That case first came to the Committee on Freedom of Association, made those points, but it was pending before the Supreme Court. The Committee on Freedom of Association asked the government to bring its recommendations to the Supreme Court for its consideration. I don't know if the government did that or not, but I do know that the Supreme Court, on its own volition, in its own reflection, in its own review of comparative law practices in this regard, and in its own humanity, indicated that there was no reason why a migrant worker, even if it did not have the papers to be working in Korea, should be excluded from what it read to be a broad definition of worker. And this was welcomed very much by the Committee on Freedom of Association. So inspiration can be taken even without referencing necessarily the Committee on Freedom of Association. And with that, I would like to thank very much Judge Kim and the panel, and thank you very much to the audience.
예, 아주
Thank you very much for your excellent presentation. Thank you, Ms. Karen Curtis, for your presentation. What I was very impressed about the presentation is that the fundamental treaties of the ILO are universal standards, and that universality can be achieved through universal ratification. And also, not only in the ratification, but we also have to take a look at the interpretation and application of the treaties, and we can see that the role of not only the executive and legislative bodies are important, but also the judiciary role is also very important. And the businesses have a role to play in the industrial relations, for example, in terms of ESG and trade agreements. And we could certainly relate to those statements. And I did speak to her just before the session, and she has mentioned that she also has a Korean copy of the compilement, and so that was very impressive. And you also mentioned a decision of the Korean Supreme Court, which was very impressive. Thank you very much.
발제로 넘어가도록 하겠습니다.
Thank you, and now we will move on to the second presentation of this session to be delivered by Professor Eun-jung Park. So please go ahead. Thank you very much. This is Eun-jung Park from the Law Department of Inje University. Now, first of all, I would like to thank the Judicial Policy Research Institute as well as all its members for hosting such an excellent conference and inviting me to this conference. And now, for me to deliver a presentation regarding ILO at such an international conference is my second time today. The first time was right after Korea ratified the conventions last year. So that was before the conventions went into effect. So at that time, I talked about the challenges for the Korean labor laws to come in better conformity with the conventions. So that was a little more than a year ago, and remember that that was at the end of April last year. And at that time, we had been thinking that there would be a lot of changes with time. But as you all know, legislative improvement. So when it comes to legislative improvement, it was little. And then more recently, we see that, there was the strike by the cargo truck drivers coalition, which was regarded as illegal by the government, and the government even imposed administrative order to force to work. And then now afterwards, the alliance stopped their strike, and now there are also talks about holding them liable for the damages. And now this type of strike or such stringent actions against such strike is before the conventions being ratified. But then now the experts believe that this is a serious matter, all the more so because the conventions having been ratified now have the same effectiveness as domestic laws. And even without the legislative amendment of the labor-related laws, perhaps we could also rely on the sanguine judgment of the judges present here today. So that is what we have been expected. But then again, we see that when there is no legal streamlining, then there are limitations on simply relying on the interpretation by the courts and the judges. And that is why perhaps I am here to talk about something that I have been repeating for the past few years. So I'm not proud of having to repeat myself, but then here I am to discuss the way forward for the Korean Trade Union Act in 2023, new resolutions for old issues. Now, it was around the time of the ratification in 2021. So I had observed some of the main problems, not the minor ones, just main problems with the Korean Trade Union Act. So first, you see the limits to union membership eligibility all the way to the emergency mediation. So I listed 9 major problems. And now there are also, for example, the civil servant as well as the education servants and the defense or the national defense workers. So they're not included here. So for example, the limitations on the collective bargaining against the public servants, or even outright prohibition against collective bargaining of the civil servants. Now they should also be included here for discussion. But then again, this is just for the most basic Korean Trade Union Act. And also regarding the public servants as well as the teachers, now I believe that that probably requires a different opportunity for us to take a deeper dive. Now, as we all know, and also Ms. Karen Curtis just mentioned, now there were also some issues that were directly related to the ratification of the conventions, and so we already had an issue with the EU regarding the FTA. So the expert panel was convened, and some observations had been made. And among the issues at the time were about the limitations on the union member eligibility, as well as the declaration for establishment of trade unions. So once again, we reaffirm that these were the issues. And then, in particular, for the large transport vehicle drivers, now this is also specifically mentioned here, which is also directly related to the issue that we have had recently. And so the fact that the cargo truck drivers not being recognized as a trade union, so now this also is a problem even to this day. Now at that time, we have provided a lot of explanations about how we are going to broaden the scope of the trade union. But then again, the recent series of events demonstrate that the occupation, or what we call the subordinate self-employed, like the large transport vehicle drivers, now their issues remain unresolved. And as we all know, in January 2021, in preparation for the ratification of the conventions, there have been partial amendments to the Trade Union Act. But still, there are some issues that stand in conflict with the conventions or that are not in line with the conventions. And also, for example, unless there are future-oriented interpretation or legal streamlining, then I believe that they will continue to give rise to issues that are similar to what we see today. So along with this, then there are some of the issues that we have to consider in line with the Korea's Trade Union Act. Of course, perhaps many of the issues related to the ILO conventions would be left to the judiciary judgments. But then even before then, there are the issues that also should be dealt with through legislative approach. So I'd just like to point out some of them. First is as we all know, the definition of a worker, or the definition of an employee. So this is something that I must bring up first. Now, legally speaking, then the definition of a worker, so in the Trade Union Act, the definition of a worker, well, I do not believe that it should be handled solely legally, because even under the current legal provisions, we can also rely, the judges have already expanded the scope of the definition already. So I believe that there's also quite a lot that we can do through interpretation. So then the question comes down to not the definition of a worker itself, but then, so based on the worker definition, what is the definition of an employer that is also tied with the issue of guarantee of the 3 labor rights, as well as the trade union establishment declaration system, as well as a single bargaining window system. But now, looking at the recent cargo truck driver strike, then I also believe that we still need to come back to the issue of the definition of a worker itself. So this is still quite important. And then about now, Ms. Karen Curtis also has mentioned that in Korea, many of the ILO decisions or the interpretations have been introduced. But now, when we look at some of the decisions, then we see that the Freedom of Association Committee also believes that those who are not in subordinate contract are still eligible to establish or join a union. So when we consider this, then the definition of a worker in Korea under the Trade Union Act, even if it is not based on subordinate employment contract, and so that even if it can include unemployed persons, persons seeking work, or specially employed workers, still, in the course of interpreting the provisions, as well as who is doing their interpretation, are still important. And they also determine the outcome of such interpretation. And regarding this, there are also quite a number of bills that have been tabled at the National Assembly. So I believe that we also need to move forward with this legislative approach to better define the concept of a worker. And now, thanks to the amendment, we were able to delete the restriction against dismissed workers from joining the union. And if we are to remind ourselves of the significance that the Trade Union Act was amended for the ratification of ILO Conventions 87 and 98, then workers must be guaranteed the possibility of engaging in equivalent levels of union activities regardless of legal status. Although unavoidable legislative considerations may be made for the uniqueness of intra-corporate labor relations, it should not be operated in ways that may reduce the scope of workers under the Trade Union Act. And next, now another issue that we need to streamline is the definition of an employer. As I briefly mentioned, now the definition of a worker in Korea cannot be understood in separation from the definition of an employer, and also the declaration for the trade union establishment is also related, because the worker's definition can be defined as the party to the collective bargaining. So let's say in the case of Korea, like daily workers or the food deliverers and golf club caddies, now they are now able to form unions, but still, even for these especially employed people who can establish trade unions, we can see through various surveys that their path toward bargaining, collective bargaining, is quite rocky and uncertain, because in most cases, those who are considered the employer claims that they are not. And as you all know, in the case of Korea, the three labor rights are highly organically linked to each other. So the right to organize or freedom of association and the right to collective bargaining, they are closely related to each other. Of course, the Constitution says that each is separate from each other, but still, when it comes to the trade union, then we see that the three rights are intertwined with each other, meaning that you need to declare the trade union to have the right to collective bargaining. And in the course of engaging in collective bargaining, then you have to be a trade union that is legally found under the Trade Union Act, so that you will also be able to have the right to request mediation, and you would also be protected under the law. So now, in this relations, then, the definition of a worker means that those who can engage, those who can create a trade union are the ones who can engage in collective bargaining. So unless you can be the subject in collective bargaining, then you do not have the right to establish trade union, which is not necessarily correct, but that has been the perception so far. So then the definition of a worker and also those who can exercise collective bargaining, and then also the employer as the party to collective bargaining. So I believe that we need to change this kind of structure, and also with the change in the definition of a worker, we also need to alter the system of declaring the trade union establishment. And also, we need to change the system of the collective bargaining as well. And considering the recent changes, then even those who are not in direct employment relations, those who still have the control to influence the working relations, or those who have the de facto control, then they can also be considered as the party to collective bargaining. So I believe that we also need to quite urgently modify the definition of an employer as such. And now here, perhaps the diagram here is not very neat, but then now this is just the diversification in the employers. And so we see that the employment relations are not just one-on-one. And I believe that this is a globally common phenomenon. So we see that in many cases there are multiple employers. So in this case, the right to collective bargaining in the past was premised on a single employer, but these days we also need to broaden the concept to also include multiple or plural employers or workplaces. And the purpose of the TUA provisions on employers is not so much to define the concept as to provide for the roles of employers to fulfill the purpose of the Act. So as such, as the ILO is also mentioning, the de facto securement of the right to collective bargaining being important, we believe that the concept of the employer should also be amended to be in conformity. In other words, so even not simply following the Trade Union Act, but then now to follow the Constitution, which also guarantees the right, then I believe that we also need to amend the concept of the employer. And third, now this is something that was mentioned earlier, and that is the Trade Union Establishment Reporting System, or the declaration system. And this was also observed several times by the ILO, and this has also been an issue in Korea for quite some time. So in many of the ILO provisions, then they provide that workers and employers without distinction whatsoever shall have the right to establish and subject only to the rules of the organization concerned to join organizations of their own choosing without previous authorization. And also, they can choose whatever form they wish. And that is why the Cargo Truck Drivers Union is not a union, but is called an alliance. And also there is the mediation right, and also the collective bargaining right, and also the initiation of the due process. So all of them are related to the Trade Union Establishment Declaration. Now, strictly speaking, this reporting system or the declaration system is not subject to approval. So perhaps we can claim that this is not in violation of the convention, but still, what we have currently is the return of the report submitted by the trade union. So this is de facto rejecting the establishment. So I believe that it is still problematic. And because this reporting system is serving as the gateway to the legal structure, so the fact that if we can just block this gateway, then this would also have a huge impact on the labor management relations. So I believe that these issues or these objections must be taken seriously. And another thing that we have to consider is the benefits to be gained. So the operation of labor relations concerning collective bargaining and action can be made easier by controlling the threshold right or the gateway of association. But are the benefits gained by controlling the gateway to the right of association a right one? So I believe that in whatever situation, the trade union establishment reporting should not serve as the gateway toward trade union establishment. So we need to either abolish this system or make sure that it really serves only as a declaration system so that it will not have any impact on the establishment of the trade union itself. And next is about the streamlining of the single bargaining window system. Now, unifying the bargaining window in and of itself is not unconstitutional, and also the ILO has given the opinion that a system of collective bargaining that gives the most representative trade union exclusive rights is not in violation of the convention, but still the Korean single bargaining window system, the issues with this is that this can also deter collective bargaining when there are plural unions, and it could also infringe upon the rights to collective bargaining by some minority trade unions. And another issue is that exercising the right to collective bargaining by supra-corporate unions is almost deprived of. And That is why we had also raised issues with the single bargaining window system several times. But now for over 10 years, this system has been in operation, and there have also been some benefits that were gained through the system which cannot be denied. So I am also against rescinding this immediately. Now, having said that, the single bargaining window system does, if it can undermine the right to collective bargaining by many unions, then this is something that have to be reconsidered. And in 2018, the Economic, Social, and Labor Council had also expressed its questions about this system, and in the early stage, it has also recommended that we put aside this system. So I do hope that we can take all these issues into consideration as we try to streamline the system. And the fifth is the prohibition against paying full-time officers. This is something that has been dealt with so many times, even at the ILO level, so I do not believe that it warrants a more detailed explanation at this point. Now, the ILO has also consistently advised Korea that the payment of wages to full-time trade union officers is not subject to legislative intervention and must be left to the parties' free and discretionary bargaining. But then, the ILO has also stated that it understands the historic complexity of the issue in Korea and has also come up with the opinion that it can also acknowledge the specificity to Korea's position. Still, now the specificity being that Korea has company-level unions, and then the payment or the wage payment to the full-time officers, and then there's also the time-off system. And now this is to limit their activities as full-time officers in trade unions, and they are still, the ILO is still quite strongly objecting against them. And this is also related to the unfair labor practices. And so, for example, if they violate the current time-off system, then it could also be subject to punishments as unfair labor practices, so that is also problematic. And also the time-off system. Now this fundamentally should be left to the voluntary determination between labor and management, and the problem is that it is currently legally mandated. And currently now any agreement between the labor and management that exceeds the currently legally mandated time-off limit would be subject to punishment. So again, I believe that this is something that should be left to the volition of the labor and management. And now I would like to move on to the sixth issue, and then the last one, which is a sensitive one, and that is about the limits on excessive damage claims. Anyway, so now number 6 is the crime of interference with business. And this is based on the Article 314 of the Criminal Act. And the ILO has also advised that this has to come in line with the freedom of association. And we see that there have been over a dozen recommendations to revise this. Now, the crime of interference with business in the Criminal Act, now this type of crime can only be found in another legal system, and that is the Japanese Penal Code, which served as the template for the Korean Criminal Act. And also it has been said that the crime of interference with business under our Criminal Act may have been formulated from the start to repress industrial action. Although there are means under the Trade Union Act to limit the application of interference with business under the Criminal Act, meaning that maybe we can revise and amend the Criminal Act. But as I mentioned earlier, the origin. So when we consider the origin of the crime of interference with business, which is highly suspected to be designed to repress labor movement, then we should also consider whether this provision has to exist at all. And last is on the limit on excessive damage claims. So as you all know, there are also legislative movements to mitigate this. For example, what is called the Yellow Envelope Bill. Now, the ILO has expressed concerns about the severe effect of actions for large damage claims on the free activities of trade unions, because damages and provisional attachments not only pose serious financial threats to the very existence of trade unions, but also have a chilling effect on lawful trade union activities. Now, the possibility of excessive damages from unlawful industrial action, as we can see from the Koje shipyard case. Now, this can and do repress industrial activities, and they can also link to the financial status of the union members, and even be linked to their right to life. And also claiming for damages even for peaceful strikes, citing damages to the employer, should be reconsidered. Now, as I mentioned earlier, there are legislative activities to make improvement, and there are also quite a lot of efforts being made in order to improve upon them through legal provisions. But then I believe that perhaps the more fundamental action could be in interpreting the justification of the industrial action, because the damage claims is when the industrial action is considered to be unlawful or unjustified. So if we can find the industrial actions to be justified, then this issue would also go away. So let's say in the if the industrial action were in violation of one or two legal provisions, and then to see that this is automatically then unjustified, strike would not be appropriate. So I believe that we need to change this perception where we equate the legal violations with unjustified strikes automatically, because there are the legal justifications, but then also the social or the economic justification. For example, for example, there are the issues of justification of the purpose of the industrial action. So, for example, whether it is justified against the current economic situation or under the current business environment. But so once we keep talking about this justification in the industrial action, then this could be linked to the damage compensation. But I believe that what we need to do is, so I believe that we need to review how we judge the justification or the lawfulness of industrial strikes in relation to the damage claims against industrial action. So these are some of the issues that I had raised in relation to the legal system in Korea to be more in compliance with the conventions. And of course, more of the key issues or the fundamental issues are left in the hands of the judges present here today. So of course, on one hand, we need to have the judiciary decisions, but also at the same time, legislative efforts as well. So that is my conclusion for today. Thank you very much.
예, 역시 훌륭한
Thank you very much to Professor Park for the outstanding presentation. So Ms. Curtis earlier has mentioned that for the ILO fundamental conventions and also the significance of having ratified them, is that it is the expression of the national commitment to accept them as the common norms and common standards for labor laws in Korea. So that is something that we can take as the obvious. But now then what is important is that having ratified the conventions and having accepted them as the common norms and standards in Korea as well, then it is now left up to the judiciary as well as the legislature to come up with the follow-up actions to be more in line with these conventions. And Professor Park, I believe, has come up with the list of things to do for us, especially the 7 issues that we need to resolve. And of course, for these issues, the labor management and government, in other words, the 3 parties, and of course, having a tripartite dialogue to address them would be the most appropriate and the ideal solution, which is also I understand that is also the preferred method by the ILO as well. But in some cases, these issues can become legal issues and can go all the way to the courts. Then how will the judiciary decide upon these issues? I believe would also be an important task given to the courts as well. Thank you very much.
Let us now go on to the discussion portion of our session. I did introduce our 2 discussants, but we were not able to introduce one of the discussants. We have a discussant from the Ministry of Employment and Labor.
So we were scheduled to have Mr. Kwon Sang-jung from the Ministry of Employment and Labor, but then he was held up by an urgent matter. So in his stead, we have Director Hwang Hyo-jung. So Hyo-jung Hwang, who is the Director of Labor Relations Legal Affairs Division of the Ministry of Employment and Labor. So for the trade unions as well as the labor laws streamlining are part of her responsibilities. So then she would provide her discussion regarding the ILO conventions from the perspective of the labor management relations. So yes, here is Director Hwang.
저희한테 주어진 시간이 사실은
We have been allocated the morning until 12 noon, and there's only 6 minutes left, as you can see. It seems that I have not been able to use the time well, but if you could spare us just 10 more minutes, we would like to close by 12:10. We will listen to our 2 panelists first, and then go back to our presenters for their comments and answers. Maybe we can ask the panelists to limit their discussions to just about 7 to 8 minutes. We will start with Judge Kim Yong-jin.
예, 안녕.
Good morning. As have been introduced, I am Kim Yong-jin, and I will jump straight into my discussion because of the time constraint. We have heard about the fundamental conventions of ILO as well as some challenges to the domestic laws, and I can relate to these challenges. But to play the role of a designated discussant, I would like to ask some questions to both of our speakers. First, regarding the remuneration for full-time officers. So we need to be able to autonomously decide between the labor and management. That is ideal. If we take a look at ILO Convention number 135, Article 2, it says that such facilities in the undertaking shall be afforded to workers' representatives as may be appropriate in order to enable them to carry out their functions properly and effectively. And if we take a look at recommendation number 143, Article 10, number 1, workers' representatives in the understanding should be afforded the necessary time off from work. But it says also in number 3, reasonable limits may be set on the amount of time off which is granted to workers' representatives. And so regarding the remuneration for full-time officers, the autonomous consultations and decisions is the most ideal. Currently, the time off limit and remuneration is defined by law, and we have a very restrictive system for time off in the Korean legal system. Well, Professor Park also mentioned this. We need to make sure that the time off limit is not too restrictive by expanding the room for autonomous consultations so that it may reflect various realities of the full-time officers. And if we see such development, then I believe that it may be in the direction of being more compliant with the treaty, with the Convention on the Freedom of Association. Next is the question concerning the scope of workers. Well, the scope of workers is quite wide in definition, but there is a law that limits the scope of workers who can organize trade unions. And so when we're talking about trade unions, there is a limit to the scope of workers. And so those who have the right to claim collective bargaining and participate in general freedom of association, the definition of the scope of workers is very large, but it's very small for those who can organize trade unions. The most recent case of the freight trade union, they are able to have active collective bargaining on behalf of the union members. And so we can see that there really is a gap between these two laws, and subordinate economic status that could be an issue that is connected to other laws such as the Franchise Act as well as the Subcontracting Act. And so I'm just asking this question for the sake of asking questions based on the recent example of the freight trade union. I wanted to know what your opinion was concerning the scope of workers. Next, related to the interference with business, it's not a question but rather a comment. If we take a look at the Supreme Court Grand Bench decision, the risk of punishment for peaceful strikes on the charge of interference with business has been greatly reduced, but the possibility still remains. And this actually, the next example is a court case that was raised in 2012, but the ruling date is in May of 2022, and the decision of constitutionality regarding Article 314 of the Criminal Act, it failed to satisfy the requirement for the qualified majority, and that is needed to declare unconstitutionality. So ever since this decision, we see that it has become very difficult to find a decision based on the charges of interference with business regarding strikes using peaceful means only. But if there are additional acts such as locking down production facilities, for example, that may be found guilty on the charges of interference with compensation. The last topic that I would like to touch upon is damage compensation. Whether liability for damage compensation is established and issues related to the scope thereof. And so we do believe that we can relate to the possibility of liability for damages that have been caused by illegal strikes. But concerning the fact that there is very abstract standards concerning the scope of legal strikes, and that actually leads to this challenge over liability for damage compensation. And what we need to do is to make sure that this scope is set, and we also need to make sure that even if the court considers a peaceful strike as an illegal strike, it is necessary to give active consideration to the reduction of liabilities. My question is concerning the scope of liability for damage compensation. I think we need to review excessive damage compensation. It's incurred by illegal acts. In Korea, we have the difference theory for compensation for damages in Korea. So this means that compensation amount is calculated by subtracting the victim's current property from the estimated amount of property the victim would have had if the illegal act did not take place. So based on this difference theory, we need to make sure that there is no excessive damage compensation that is charged based on illegal strikes. The reason why we sometimes feel that the damage compensation is excessive is because the scope of compensation for damages should be reviewed. Recently, in the Supreme Court, concerning the scope of compensation for damages incurred by illegal strike is being reviewed, and so I think we may see new interpretations in the near future. The current damage compensation calculation based on the difference theory means that the strikes that chose to occupy production facilities and bans on replacement workers do persist, and so the double-sided effect of maximizing the effectiveness of strikes while increasing the damage of employer is actually being pursued by the trade unions. And so we need to remember that in the case of illegal strikes, especially if there is occupation of production facilities, it could lead to very high damage compensation. But we need to first clarify whether the current damage compensation levels are excessive. I would like to raise these issues with both of our speakers. And according to recent data, we can see that one of the biggest reasons for damages due to strikes is the occupation of production facilities. And of course, companies are not expecting to actually receive damage compensation in full from the subcontracting workers who are not able to pay these compensations, but this system is being used by the employers. And so I wanted to raise these questions despite the excellent presentations, because that is the role of me as a panelist. Thank you very much for your presentations, and I would like to address all of these questions to both of our speakers. Thank you very much, Judge Kim, for your discussion.
과장님께서
Thank you. And now let me go to Director Hwang. Thank you very much. Good morning, ladies and gentlemen. This is Hyojung Hwang from the Labor Relations Legal Affairs Division. Now, Ms. Curtis talked about the ILO convention's meaning and also how it can also be helpful for growth of inclusive economy. Then also Professor Park talked about how the Trade Union Act was amended to prepare for the ILO convention ratifications, but still we still have some areas of improvement. So thank you very much for the presentations. Now, with regards to the progress and also the significance of the ratification of the ILO fundamental conventions, then now they have already been covered in the paper that was already submitted. And let me just jump right into the discussion. And now Professor Park has listed 7 issues regarding the Korean labor laws and the ILO convention, and of them, what is important, I believe, are the definition of a worker and also the trade union establishment reporting, and also what is currently being discussed quite a lot, and that is about the yellow envelope bill or the amendment of the Acts 2 and 3. So I would just like to focus my discussion on that. Now, as we all know, the definition of a worker is quite broadly defined, and also through legal precedents, we are now having more and more concrete definition, and especially in the 2008 for the textbook tutors, the Supreme Court also has given some guidance about the definition of a worker. So I would say that actually it is quite broader than the Labor Standards Act. And it is based on that the government has also broadly recognizing the right to organize even among the specially employed workers. So for the specially employed workers not having the right to organize, or in order to recognize the right to organize among the specially employed workers, we need to amend the concept of a worker. I cannot agree with that because it is already quite broad, and I believe that it stands to be even broadened. Then also, for example, the chauffeurs or the delivery workers, and also the textbook tutors. So we see that such not only the specially employed workers but also the platform workers, they have their union. And also, of course, we are talking about cargo truck drivers, but then now they have already declared their unionization. But then now for the cargo truck driver alliance, as we have also said to the media so far, now it consists of a variety of type of individual businesses, and there are about 20,000 to like 25,000 workers who are actually in different fields and different forms of employment. So we have not individually taken a look into this yet. And also for the cargo truck drivers alliance, I'm not sure whether they still consider themselves a union, because if they do, then they would also have to follow the legal procedure. But most fundamentally, so for example, the single bargaining window system or going through the mediation process before going to strike, and they have never followed such legal procedure yet. So that is something that we took into account, meaning that they appear to consider themselves not a union. So that is what we took into consideration. But then I would like to point out that it is not factually correct that we are denying the status of worker for the cargo truck drivers, or that we are denying their right to organize. And of course, the labor market today is becoming more and more diversified, and also for the employer, so perhaps the concept of a single employer is limited. So I also agree with the observation, especially in the case of Korea, we have the large discrepancy between the principal contractor and the second-tier contractor. So I believe that there are a lot of demands to make changes. So for example, for the Daewoo shipbuilding strike in August, there were also damage claims, and that have also been quite a controversy. But just because it was a problem, we also have to think about whether this can be addressed through bargaining. So for example, if we are to mandate the principal contractor as the party to the collective bargaining and to, have them to the collective bargaining, because if not, then they could be legally subject to punishment. So we also have to be more cautious in this approach, and especially regarding the yellow envelope bill that is tabled on the National Assembly. So there are actually about 10 bills that have been proposed at the National Assembly. And among them, the definition of employer, so it says like those who can have de facto control. That is one definition that is offered. Another is that when there is a contracting relations, then those who is giving out the contract should be seen as the employer. So that is another proposed definition. But then now the de facto or effective control, now this is quite ambiguous, quite abstract. So let's say if I have been requested to bargain, then am I really the employer who has a right or who has the obligation to engage in the bargain? It is actually quite questionable, and it is not clear in the definition. So that is why the Central Labor Relations Commission, they have also recognized only 1 out of 4 such cases last year regarding Hyundai Group. But anyway, so this probably is on a case-by-case basis. But then, in the case of Korea, this could also be subject to criminal punishment. So, and this could also be directly linked to confusion on the field. So again, we need to have a very cautious approach. And I believe that this can also deny the essence of the subcontracting relations. The fact that you have a subcontracting, meaning that I have delegated a part of my business without wanting to be involved in that business, then do we still hold them as the employer when they have already taken that part of the business and contracted that out to another company? And that would also deny the concept of subcontracting. And also in the case of Korea, if we have a collective agreement, then because of the legal effectiveness, now then, when there is a collective agreement between the principal contracting company and the labor union of the subcontractor, then this means that this would also apply to the subcontractor even when they were not directly party to the collective agreement. So that could be another question. And also when it comes to the obligation to engage in bargaining, then also what should be the unit of bargaining, and also what should be the workplace subject to the bargaining. And so what is going to be the unit for the window? And also if there are several or multiple unions in the multiple subcontractors, then what should be the extent of seeing them as party to the collective bargaining? And so we have to take a comprehensive look into this, thinking about all the different factors that could have an impact. So it's not just about expanding the concept of employer to address this issue. And then also regarding the yellow envelope bill, and so regarding the Article 2.3, and then also Article 3. Now the bill says that unless they are violent or destructive strike, then you cannot claim damages. And even if they are violent and destructive strikes, then you can still hold only the union liable, not the individuals. And also they are introducing a cap. So let's say if by the damage compensation the union can no longer sustain itself, then you cannot hold them liable. So the bills include a lot of such provisions. So then these are the kinds of provisions that do not consider the balance with the right to property of the employer. And also in the Damage Compensation Act, the basic legal principle is to hold liable those who inflict damage upon others' property, and to waive that in this bill, I believe, is not in line with the existing law. And also, as Judge Kim has mentioned earlier, we have also done a status survey in Korea, and the biggest problem in damage claims is the illegal occupation of the workplace. And for this, the courts are also levying hefty damages for that. So, for example, if you forcibly occupy the workplace, or if there is violence accompanied, then there have been quite a number of such cases. And just to exempt liability for all those cases, then it has given rise to more unlawful strikes, and that is also something that we have to consider. So what we call the yellow envelope bill, I would say that the government finds it hard to accept them. So due to the time constraint, let me conclude here. Thank you.
예, 두 분 토론 감사합니다.
Thank you very much for the two panelists. In particular, I am sure that the Ministry of Employment and Labor has much to share, but I am sorry that we were not able to allocate more time to the panelists. Thank you very much for keeping within the time limit. I can see that we are far past the time that I had additionally asked for, which makes me quite an unsuccessful moderator today. So we have listened to the speakers and panelists. I can see that not only do we have some issues in the limelight, but at the same time, we do need additional discussions concerning these very issues. During the afternoon, we do have a final plenary session after session 4, and session 4 also will cover similar topics. And so, because we have a final plenary session after session 4, we look forward to further dialogue during the final plenary session. But having said that, of the two speakers that we have on stage, if you have any brief comments, just maybe a minute or two if you wish to, concerning the discussions that have been made, we would like to give you the floor if there are any comments.
Thank you very much. Actually, I have many, many comments, but I will keep them for the next sessions. But I would like maybe just to pick up one point, because I know it's something that's very, very much discussed and of interest, which is this first question that's been raised both by Professor Park and then by the discussants, which is the question of the definition of worker. I'm sympathetic to the points made by the Ministry of Employment and Labor that it's quite broad, and so if it's quite broad, that means it can be broadly interpreted, and that means that we can be talking about all workers, self-employed, any type of worker, group of workers that come. And then we come to the question of what is an employer, and the movement of the legislation towards what is an enterprise-based labor relations. And I think that that's where we get into the kind of difficulty, because of course with self-employed you will not have an enterprise-based labor relations. So I would say that it's not enough, the discussant, I'm sorry I forgot forgot his name, but the discussant raised the question of whether freedom of association in general is okay. Well, no, because you cannot exercise your freedom of association if you're not assured the protection of those rights. And that's what the law provides. That's ensuring that you're protected against unfair labor practices, that you're not sanctioned for your industrial action. So there's a need to see how to bring in self-employed workers, not only to the notion of a worker, but so that they can actually organize a union which has the protection afforded by the Trade Union Labor Relations Act. And that doesn't mean the exact same type of collective bargaining scheme, and that the Committee on Freedom of Association has regularly stated. It does not mean that. There can be a different type of scheme, so you might need to bring into the legislation the fact that these different groups have a different way of engaging in labor relations, but it's important that their engagement is protected. And so it's very important that they are not sanctioned because they're not seen as a union that is covered by the Act and that any exercise of their action is sanctioned. So I think I'll stop with that, but there are many, many other issues I would like to raise, and I'm sure that they will also be raised by the speakers in the afternoon session. Thank you.
예, 뭐 앞에서
Well, then it was mentioned earlier by Ms. Curtis. Yes, I also have a lot of comments to make, but I would also like to hold myself back. And now, as Ms. Curtis talked about the concept of worker, I would just like to focus more on the concept of an employer. Now, as was mentioned so far, now the legal definition of an employer, of course, that itself is not easy, and especially when it involves the criminal punishment, and then the ambiguity or the abstractness of the employer, I understand, could also be related to the further legal complications as well as legal punishment. So then, for example, just simply broadening the concept of employer and also the broadening of the parties to the collective bargaining and also the recognition of the multiple or the plural unions. Now, they also have to be linked to the review of the legal punishments under the Korean law. So this is not just about the employer definition, because in the laws in Korea today, then there are a lot of provisions meting out legal punishments on the unions, and I believe that they have to be considered together with the concept of the employer as well as the legal punishment of the employer as well.
이제 3세션
We do need to close session 3 at this point in time. Thank you very much for the outstanding presentations, as well as a big thank you to our 2 panelists as well. Well, in fact, concerning this topic, the Judicial Policy Research Institute has already published a paper on this topic this year, and it is titled The ILO Fundamental Conventions as well as the Challenges of Labor Law in Korea. I understand that it is uploaded on their website. I hope that judges and lawyers will refer to this material as needed. During session 4 in the afternoon, we will continue our discussion on this topic. And through session 3, I do hope that we were all able to have a better understanding of ILO fundamental conventions, and I hope that it will contribute to setting the direction for the application and interpretation of these fundamental conventions in Korea. Thank you very much for your participation, both online and offline. This brings us to the end of session 3. Thank you very much.
Receive for all participants for giving us an informative overview of the interpretation of the ILO fundamental conventions in Korea and the future challenges for our courts. Please give all participants of the session 3 a big round of applause. This brings us to the end of session 3. We'll continue the session 4 at 1:30 p.m. after a luncheon break. Thank you. Ladies and gentlemen. Distinguished guests, we are soon starting session 4. For those who are outside the conference room, please make your way to the conference hall and take your seats. Thank you for your kind cooperation. 네, 기빈 여러분, 컨퍼런스가 곧 시작될 예정입니다. 행사장 밖에 계신 분들은 행사장 안으로 조속히 입장해 주시길 부탁드립니다. 감사합니다. Distinguished guests, today's conference will begin shortly. For those who are outside the conference room yet, please enter the conference room and be seated. Now I'd like to invite the moderators, speakers, and panelists of the session 4 to the stage. Thank you. Simultaneous interpretation service will be provided during the whole conference. Please take your receivers and select channel 1 for Korean and channel 2 for English. I would like to ask you to turn off your cell phones or put them on silent mode, and please keep wearing your face mask to protect yourself from COVID-19. Thank you for your kind cooperation. Welcome back, everyone. Luncheon. Before we start the session 4, I would like to remind you that how to ask your questions to the speakers. Those of you who are in the floor can leave your questions on YouTube comment section. And we are holding a real-time viewing certification event. You can get detailed information as to this event on the More from YouTube section. Now, we'll commence section 4. In session 4, we'll deal with the ratification of the ILO Fundamental Conventions and challenges to labor law in Korea. It gives me a great pleasure to introduce our moderator of this session. The moderator of this session is Honorable Justice Han-Soo Kim from Supreme Court of Korea. He received an LLB from Seoul National University College of Law. He has been practiced as a lawyer since 1988 and gained extensive practical experience with his wide-ranging activities as an attorney for the last 30 years of his legal career. He is widely credited for playing a pivotal role in entrenching democratic order and values in our society by setting a host of meaningful precedents regarding the Constitution and the labor law, and devoted to establish standards for labor relations. He has previously served as an adjudication member of public interest at the National Labor Relations Commission, a standing member of Economic, Social, and Labor Council, a non-standing member of the Supreme Court's Judicial Reform Committee, and Secretary of the Presidential Committee on Judicial Reform. Ladies and gentlemen, please greet him with a big hand of applause. Now, I'd like to turn over the podium to Justice Kim.
Good afternoon, ladies and gentlemen. As introduced, I am Sun-Soo Kim, with the privilege of serving as a moderator in this session, Session 4. Thank you very much for your invitation to this very meaningful conference. Now, today, on this day 2 of this international conference, we will be discussing So we are having this day 2 meeting under the theme of ratification and domestic implementation of the ILO Fundamental Conventions. Now in this session 4, we have 2 speakers and 4 panelists. Let me first introduce the panelists here with me. First, we have Presiding Judge Dong-hyun Kim of the Seoul Central District Court. Judge Kim graduated from Seoul National University School of Law and obtained a master's degree in bankruptcy law from Seoul National University Graduate School and completed a doctorate in labor law from Chungnam National University Graduate School. As far as I remember, when he was serving in the District Court of Daejeon, now he has also written a judgment finding not guilty for in the case of the railroad strike when he was in the District Court of Daejeon. So thank you very much.
My great honor to speak with this distinguished guest. Sorry. I prepared this presentation in English. However, I think it would be better to deliver these issues in Korean because they should be known more to Korean practitioners. So,
지금 뭐 발표하는 거예요?
네.
그 전체 소개하고 난 다음에.
Well, would you like to wait until we introduce everyone before you start?
발표자와 토론자 모두 소개.
Okay, so then we will finish the introduction of all the panelists and then we will start the presentations. So now then the next speaker, if I may introduce him, it is Professor Sung-wook Lee of School of Law of Ewha Women's University. Now he is currently the professor at Ewha Women's University after Busan National University, and he has also been actively involved in the labor policy making as well. And he is also currently a member of the National Labor Relations Commission as the public interest member. So please welcome him. And now let me introduce the panelists. First, Ms. Karen Curtis, Chief of the Freedom of Association branch of the ILO. I understand that she was also the speaker in session 3. So please welcome her with a big round of applause. And the next panelist is Mr. Xavier Bourdonnais, Head of Unit of the Collective Bargaining Coordinator of the Freedom of Association branch of the ILO. So he was also a participant in session 2. So please welcome him with a big round of applause. Next are, so the next panelist is Attorney Yongmun Kim from Dentons Lee. As an expert in addressing labor and employment issues, Attorney Yongmun Kim has served his clients on a range of matters involving individual employment relationships. And please welcome him with a big round of applause. And also, as a panelist, we have senior researcher Erim Yoon of Seoul National University Law Research Institute. So she is currently lecturing labor laws in Seoul National University as well as Hanyang University. And she was a visiting scholar at the International Institute for Labor Studies of the ILO, and she's an advisory committee member at the National Human Rights Commission of Korea as well. So please welcome her. Thank you. And now let me go to Judge Dong-hyun Kim to discuss challenges of Korea's collective labor law related to international labor standard. And please keep to the 30-minute limit. Thank you.
And the introduction. Although I prepared this presentation in English, but I think I'm going to speak in Korean from panel discussion. Because I want these issues should be known more to Korean practitioners. Because time is limited, I'm going to abbreviate some part of what I prepared. Today, I'll try to reveal the gap between international labor standards and Korea's collective labor law. As the title of this presentation implies, the ratification of the ILO Fundamental Conventions is a big challenge to Korea's labor law. However, it is still hard to find any clear solutions. Although I'm afraid this presentation may not be sufficient to give solutions for specific cases. I hope it may provide an opportunity to recognize the problems that lie between domestic and international laws, and to let us move forward to solutions step by step. Before we discuss the main contents, I'd like to introduce a book to everyone. I published a book together with Dr. Hae-young Lee in April 2022. This book deals with prospects of Korea's collective labor law practice since the ratification of the ILO Fundamental Conventions on freedom of association. And what I'm going to tell you today is mainly based on this book. Please refer to the book above if you need further information. Then let's see closer the challenge to Korea's collective labor law. What I want to talk about first is self-employed workers' right to join trade unions. Korea's government explains TULRAA, or Trade Unions Act, does not allow pure self-employed workers such as franchise owners to join trade unions. However, it is not so clear that franchise owners don't fall within the category of employees. A lot of franchise owners are subordinate to franchise companies, and a lot of countries, including Japan and France, apply parts of labor relations law to franchise owners. ILO CFA says the determination of conditions of eligibility of union membership is a matter that should be left to the discretion of union bylaws, and the public authorities should refrain from any intervention which might impair the exercise of this right by trade union organizations. It was commented in Korea's case. In addition, CFA also says insured workers who are self-employed could fully enjoy trade union rights in Dominican Republic's case. On the other hand, the issue of self-employed workers' union membership leads to a kind of trade problem. The EU, one party of the EU-Korea FTA, has been arguing this is not consistent with freedom of association. The panel of experts recommends that Korea revise the Trade Union Act to permit self-employed workers to join and remain members. According to all above, we may see that Korea's government's stance shows a considerable difference from international labor standard. Let's see the next issue. Korea's Public Service Union Act denies prison guards and labor inspectors right to join trade unions. However, CFA is continuing to recommend directly in Korea's case to allow prison guards and labor inspectors to establish and join organizations of their own choosing. Therefore, the act may be considered it doesn't meet CFA's recommendations. While the act seems to assume prison guards and labor inspectors are performing the function of police or armed forces, it may be problematic in terms of freedom of association to strictly restrict the right to organize instead of the right to strike. Although revised Trade Unions Act, Section 23(1), recognizes union membership of dismissed workers or non-workers, eligibility to be elected as representatives of trade unions is limited to only employed union members in enterprise level. It may be hard to say that there is a significant change from the previous law because non-union members' eligibility is still denied in enterprise level as the previous law and enterprise level unions are the mainstream in Korea. This doesn't seem to be consistent with ILO's stance. ILO CFA has been urging Korea's government to repeal the provisions making non-union members ineligible to stand for trade union office. The EU, the party of the EU-Korea FTA, also has criticized this as a violation of the principle of freedom of association. Expert panel explicitly pointed out the eligibility restriction provision is not consistent with freedom of association. Revised Trade Unions Act repealed the prohibition of the payment of full-time union officials by employers. Instead, time of system or working hour exemption system substitutes it. Time of system exempts union officials from working hours decided by time of decision committee. However, payments exceeding the time of decision limit may be subject to penal sanction. CFA says to Korea, the overall determination of wage payment to full-time union officers will be left to free and voluntary negotiations between the parties without legislative interference. However, it may be difficult to say there is no legislative interference with regard to penal sanction for the violation of time-off system. In General Survey 2012, ILO states it has no objection in principle with regard to employers' contribution to trade unions' financing. Convention number 135 also provides some facilities shall be afforded to workers' representatives. Therefore, it is difficult to say that the payment of union officials infringes the union's autonomy. Trade union rules need autonomy. However, Korea's Trade Unions Act gives public authorities the power to control trade union rules, although that is limited to the case where the rules are illegal. This is the correction order system. ILO Convention number 87, Article 3 provides, trade union has the right to draw up their own rules in full freedom, and the public authorities shall refrain from any interference which would restrict this right. ILO General Survey 1994 states, when the public authorities have the right to require amendment to the constitutions, it may constitute interference contrary to Article 3.2 of the Convention. This correction order system actually works in the field. In 2012, the public authorities imposed a correction order on teachers' union rules, which allow dismissed teachers to join the union. Back then, the Teachers' Union Act prohibited dismissed teachers from joining the union. KTU's representative was found guilty for disobeying the order in a lower court, although the Supreme Court overruled it as the act was revised to grant dismissed teachers union membership. Yeah, let me skip this because time is running out. Yeah, next issue is about subcontracted workers. Subcontracting system is often used as a way to evade the guarantee of trade union rights, while subcontracted workers often are working under main contractor's supervision. The workers have a hard time demanding improvement of employment conditions because main contractors are not nominal employers. Subcontracted workers need to demand collective bargaining to main contractors, which can substantially determine employment conditions. However, this issue is not resolved yet. Lower courts' decisions are not unified, and there is no precedent of the Supreme Court. This is a very sensitive issue. If the person considered as an employer rejects the employee's collective bargaining request, he may face penal sanctions for unfair labor practices. ILO CFA is afraid subcontracting might be used as a way to evade the application of the freedom of association. According to CFA's stance, a strike for collective bargaining purposes to the main contractor company by subcontracted workers is not illegal. Furthermore, CFA states subcontracted workers should be able to have collective bargaining with the party who determines the terms and conditions of employment. The latter would largely be the main contractor. The next issue is teachers' right to strike. The Teachers' Union Act prohibits any industrial action, including strike. However, CFA urges Korea's government to make sure that teachers in the public and private sector enjoy the right to strikes to defend their own occupational interests. The next issue is the goals of strikes. The goals of strikes is also a significant issue. Whether the strike is illegal may depend on it. The main stance of the Supreme Court is only mandatory collective bargaining subjects can be legitimate goals of strikes. Therefore, strikes for voluntary subjects, including management issues, can be illegal. Where the goals of strikes are unjustified, it may result in penal sanctions and claims for damage. However, ILO CFA has a stance that the right to strike should not be limited solely to industrial disputes that are likely to be resolved through the signing of a collective agreement. It seems to be contrary to the Supreme Court's stance. In this regard, CFA requested Korea's government to set aside the narrow interpretation of the legitimate goals of strike action. According to CFA, the goals of strike action should be in relation to all social and economic matters of direct concern to the workers, without limiting to the purpose of signing of a collective agreement. Yeah, let me skip this issue too. Yeah, what I want to talk the next is peaceful strike and penal sanction. In the past, even for peaceful strikes, if they are illegitimate, most of them are subject to criminal charge of obstruction of business under Section 314 of Penal Code. Of course, the practice was showing significant difference from ILO's stance. ILO CFA states firmly penal sanctions shouldn't be imposed on peaceful strikes. Korea's practice faced a change since the Supreme Court decision in 2011. The Supreme Court's ruling presents two requirements for applying the crime of obstruction of business. One is without the employer's expectation, and the other is serious mass and enormous damage. In general, it is not easy to meet the requirements for suddenness because labor disputes mostly precede. Since the Supreme Court decision, most cases on peaceful strikes have been acquitted. I suppose even the number of criminal charges has been decreased. Nevertheless, ILO CFA is afraid the standard is still broad and does not exclude the application of obstruction of business to peaceful strikes. Even a legitimate strike action could be impeded, even if at the end of a lengthy judicial process they are acquitted. Therefore, ILO seems to think the application of Section 314 of Penal Code could still violate the freedom of association. Korail is Korea's public railway company. Korail's union went on strikes twice in 2013 and 2014. The railway company declared the strikes illegal and pursued a lawsuit against the union and its individual officers for damages amounting $16 million. The company seized the union's asset and the union's bank account was frozen. Of course, it was a serious blow to the union's activity. In this regard, ILO CFA expresses concern to Korea's government. It sympathizes union's indication that such hefty damage claims not only pose a severe financial threat to the very existence of the union, but they also have an intimidating effect and inhibit legitimate trade union activities. The committee remarks the possibility of violation of the union's free functioning right. This issue is also debated in Korea's legislature, and it's very difficult to resolve because damage claim restriction may cause employers' property rights to be essentially restricted. Next issue is prohibition of political activities. Both the Public Service Union Act and Teachers Union Act prohibit political activities. There is a special context in Korea that has traditionally placed great importance on the political neutrality of public officials and teachers. ILO also understands this specialty in the issue of public officials. ILO's main stance is that a general prohibition on political activities are contrary to the principles of freedom of association. ILO states, trade unions may express publicly their opinion regarding the government's economic and social policy. In this context, ILO CFA emphasizes a general prohibition of any political activities is incompatible with the principles of freedom of association and requests Korea's government to ensure that public officials, trade unions have the possibility to express their views publicly on the wider economic and social policy questions which have a direct impact on their members' interests. Of course, strikes of a purely political nature do not fall within the protection of Conventions number 87 and 98. Now, here is the conclusion. Today, I focused on revealing the difference between the reality of Korea's labor relations law and international labor standards. There is significant difference between them. I think narrowing the gap wouldn't be easy because applying international labor standard to a specific issue could have impact even on whole structure of the domestic law. Interpretative methods alone may be insufficient to overcome the difference. Legislative solutions may still need to be accompanied. However, what we need first of all, not only in interpretation but also in legislation, is to respect the international labor standard. I think that's why legal community needs to gather wisdom. That's all I've prepared for today. Thank you for listening. Thank you for having me.
예, 발표 시간.
Thank you very much for keeping within the time limit. Thank you very much for your presentation. Presiding Judge Kim Dong-hyun talked about how we have ratified the ILO fundamental conventions, but despite the ratification, he has talked to us about 11 challenges related to the labor laws in Korea, as well as the judgments of Korean courts that are not on par with the ILO conventions. And he also talked about how not only should we have interpretations, but also legislations to respect international labor standards.
ILO 기본약.
Thank you. And now we will move on to Professor Sung-wook Lee, who will tell us about Korea's challenges and responsibilities following the ratification of the fundamental ILO conventions. Thank you. And please also keep to the time limit. Yes, hello. I am Sung-wook Lee from Ewha Women's University. Now, as we all know, the ILO conventions, including the number 87 convention, so the fundamental conventions have been ratified by Korea. And the fact that we have ratified them in and of itself is not what matters, but what matters even more is how we're going to faithfully implement and comply with the conventions and the provisions there too. So it is from this perspective that I would like to deliver my presentation. Now, for the ILO conventions and also from the supervisory bodies, so they have the standards that might also stand in conflict with Korean laws, but this has been addressed in detail in earlier sessions. So for me, rather than going into the particular issues, I would like to talk about the implications or the duties that are bestowed on the government in a broad sense. In other words, the judiciary, the executive, and the legislature from the ratification of the convention. So how is the government going to fulfill their duties under these conventions? And not only the ILO conventions, but then also for the courts in Korea that are at the bastions of the last bastions of the protection of these laws and the conventions. So what should be the attitude for the courts, and also what should be their direction down the road when it comes to the ILO conventions is going to be my main topic.
잠깐만 이게 넘기는 어떻게 넘? 예. 기본 협약의 그에 대해서는
Now, then, regarding the significance of the fundamental conventions, I would say that there are largely threefold. First is about the world of work. So in the world of work, the ILO fundamental conventions provide the minimum common standards and the value system accumulated over 100 years. And they are the basics, the fundamentals of the over 200 conventions of the ILO. So what this means is that the fundamental conventions in and of themselves are the means, and while at the same time, without fulfilling them, then the implementation of the other conventions are not sure either, meaning that the fundamental conventions are the essential means to establish the right labor order in the world. And second is that they reaffirm the social values. So around the time of the ILO's establishment, which was around 100 years ago, at that time the tripartism. So that was the breakthrough concept that was proposed by Edward Fellon, who was a civil servant in England, at that time 31 years old. And so I would say that it is his vision ideal that have been embedded into this convention. And then the third is the most important one, and that is now by ratifying the conventions, including the number 87, this also means that Korea has clearly presented its direction for labor relations in the future and has also announced such commitment by the ratification. And now the conventions also serve as the compass for, so it says, a reliable compass in any weather. So it is the compass for Korea's labor laws amendment or improvement. So reliable compass in any weather is also the subtitle in the ILO's report this year. But anyway, so I would say that the Convention on Freedom of Association will serve as a reliable compass for Korea as well in improving its relation in labor laws. Now then, especially for number 87, the domestic legal significance of Convention number 7 is as follows. Now, there are the rights and duties provided for in Convention number 87, and the ratification of the Convention is a declaration of the state to protect these rights and obligations by law and practice. So let me be a bit more specific about what this means. So now the right holders without a question are the workers, employees, and their organizations. And then the state is the duty holder to protect them. Now the state has the passive obligation not to intervene too much in the labor management relations, and it also has the affirmative obligation to prevent the intervention by third parties and also to provide remedies where needed. So the passive obligation, in other words, the obligation of non-action, and also affirmative obligation, which in other words is the obligation to act. So these duties are intertwined with each other, and the state's obligations are largely threefold. First, it has to undertake affirmative legislative actions to protect the rights of the labor and management. And second, it also has to undertake necessary and appropriate administrative actions to make sure that there is no infringement of the rights. And third, in the event that there is an infringement of the rights, then there has to be affirmative administrative remedies and actions taken to prevent repetition of such infringement in the future. Now, the state's duty to respect, protect, realize, and promote the freedom of association. So in this case, state comprises legislature, judiciary, and executive. So for the administration, if it were to, or the executive were to intervene in the labor or management relations, or if the judiciary were to not undertake affirmative actions to protect the freedom of association, or the legislature, if it fails to undertake the necessary measures to protect the freedom of association, then they all stand at risk of violating the number 87 convention. So then, if I may be a bit more specific about such duties. Now first, about the obligation to respect the freedom of association. It means that the state shall not violate this right itself in the exercise of its authority. So this is the most basic of its duties. And this also means that the state will face certain self-limitations in the exercise of its powers. So from the passive aspect, it means that the state will not take any measures denying the freedom of association, or any measures that infringe upon its essence, or take any measures that restrict the freedom to the point it becomes meaningless. Now, the affirmative aspect means that the state bears the obligation to take all measures actively necessary to realize the freedom of association. And for the state, any measures intentionally rolling back the realization of the freedom of association may be presumed to be a violation of Convention number 87 as well. Now, the obligation to protect the freedom of association, it means that not only the state, but also the workers or employers or the organizations. In other words, the state bears the obligation to take affirmative measures to protect the workers, employers, and their organizations' freedom of association from threats or infringement by not only the state, but also a third party, such as individuals or corporations. So again, this entails a number of duties. For example, the obligation to protect includes the state's obligation to take necessary ex-ante legislative and administrative measures to prevent infringements of the freedom of association, and grant judicial and other appropriate relief post facto, including investigating the freedom of association infringement and imposing appropriate legal sanctions on the infringing person. Now, infringement by the state or the state authorities, again, this is something that should not happen. So when it does happen, in other words, when the state does infringe upon the freedom of association, then the state shall seek appropriate legal measures to prevent it in the future. Now, this is the duty that automatically arises from the number 87 convention and the most basic of all duties to protect the right to organize. And next is about infringement by private parties. Now, if the state does nothing about it and if it just disregards the event, then this also constitutes violation of its duties, because the state bears the affirmative duty to prevent or exclude infringement on freedom of association through legislative and administrative measures, and thus the state is required to take all reasonable measures it can with due diligence, and failure to do so may give rise to state liability for the violation of Convention number 87. And as for those injured by the infringement on freedom of association, the state also is obliged to provide appropriate remedies. So the state is obliged to prevent, investigate, and punish any infringement of the rights recognized by number 87. And also, in terms of the remedies, they include restitution, compensation, and guarantee of non-repetition, and so forth. Next is the obligation to realize the freedom of association. What this means is that the state has the obligation to take all appropriate legislative, administrative, and any other measures to realize the freedom of association and the right to organize. Now, here, largely, there are three things. First, it includes legal and institutional foundations that enable the realization of the freedom of association. And second, to provide education and campaigns targeting civil servants in fulfilling their duties and the general public, raising awareness for the respect of the freedom of association. And third, monitoring the decisions and implementation of policies on the freedom of association and the right to organize. And going further, not only the legal foundation, but also creating the social and cultural foundation, I believe, is part of the state's obligation to realize the freedom of association. This means that the state's obligation in this case is open-ended in nature. Then now, how is the Convention number 87 being implemented domestically? And this is not just for the legislature, executive, or the judiciary. In other words, it's not just about implementation by one branch of the state, but it should be implemented by all branches of the state. And because the ratifying party of the convention is the government, so the duty to implement the convention should primarily be done by the government, in other words, inside Korea first. So it has to be done domestically first, and then the ILO supervisory bodies can conduct monitoring on the implementation, and it plays a supplementary role in supervising the domestic implementation. And to ensure the implementation of the number 87, I believe what we need is mechanism to verify the conformity of domestic laws and practices with the convention. So first, when there is a law, then we have to, in advance, review whether it is in conformity with the international standards. So we need to have that kind of mechanism. And then now, in terms of legal execution, once again, we need to have the mechanism to make sure that the legal enforcement is in conformity with the international standards. And also third is the kind of mechanism to prevent infringement of the convention. So we need to have the type of three-part mechanism to verify the conformity to the convention. So again, to be more specific, implementation by the legislature means that first, the legislature as a principal authority to take measures for the appropriate domestic implementation of Convention number 87. Now, earlier we also heard about some of the issues that might stand in contrast with the fundamental conventions, but anyways, the legislature must undertake measures to make improvement on such potential contradictions. And so this is in the case of offensive contradictions of the number 87 with the Korean laws. And there's also the passive contradiction. In other words, when there is lack of law that would make Korea more in line with conventions, then it means that the National Assembly shall take new legislative measures and undertake the realignment of domestic law. And not stopping there, but the legislature bears the duty to take continuing and ongoing legislative measures after the ratification of the convention to correct domestic laws so no violations of the convention arise. Now, the judiciary's actions are basically post facto, but then for the legislature and the executive, they are more for prevention. In other words, to prevent the infringement of the freedom of association and the right to organize. Now, in order to prevent such infringement, what it also means is that we need to provide training and education to the civil servants who are at the front line of implementing the convention. So this means that we also need to create a culture that accepts the freedom of association. And the implementation by the judiciary. Now, the judiciary is the body charged with the ultimate and final guarantee of the implementation of Convention number 87 in the domestic legal system. So for the domestic courts, they have the duty to review and provide effective remedies for infringements on the freedom of association based on Convention number 87. Doing otherwise could also constitute violation of the convention. Now, immediate issues in the courts raised by the ratification of the Convention number 87 is, now as was mentioned by Judge Kim just now, I would just like to look at some of the case laws, among many, focusing on some of the more problematic cases. And first is case laws regarding management decisions and collective bargaining. So this is something that I'm sure that we all know about, and also the Judge Kim also mentioned this. But then now, in Korea, the case laws say that the management decisions are under the sole authority of the company, but then the convention says otherwise. But what is important is that for the freedom of association, again, as I mentioned earlier, the Korean case laws pretty much exclude the union's involvement in the business decisions. But then this is highly restrictive compared to the international standards and also the laws of other countries. So if we are to exclude the management or the business decisions from collective bargaining, means that this is precluding labor management discussion or dialogue regarding them when we need labor management dialogue in this. And that could actually further trigger the worsening of the labor management relations. So this is the kind of a court attitude that I believe must change. Next is about the justification of industrial action, and this was also mentioned by Judge Kim and in the previous sessions as well. And again, regarding the justification of industrial action, again, this is too strict, and the requirements are also too stringent. So there are 4 requirements that must be fulfilled for the courts to find that the industrial action is justified. And the Freedom of Association Committee repeatedly expressed concerns about the Korean legal precedents. But again, the Korean precedents are likely to stand in contrast of the international labor law precedents, and also compared to other countries, they are too strictly interpreted. And what I believe is the most problematic is the justification of the industrial action that are liable to criminal punishment and those that are liable to civil actions. And in both cases, the justification for industrial action are both quite strict. And so I see this as a problem, and I believe that is why it is prone to give rise to civil liabilities. So I believe that the standards for civil liability and criminal liability has to be different. But what we're seeing now is that they are on the same line in both cases. And I believe that for civil waiver or the civil exemption of liability, now basically if there was no violence associated, then there should be a civil exemption given. And so as I understand that the U.S. Legal precedents are also along this line. And next is about the excessive damage claims, and this was also the subject of many concerns by the ILO. And in this case, it is not the damage claim itself that is a problem, but then I believe that this is something that arises from the judgment on the justification of the industrial action. So, especially when it comes to the civil liability. So, if the courts or the legal precedents were to change regarding the justification of the civil liability, then I believe that the damage claims regarding the so-called unlawful industrial action to a large extent would be mitigated. But now, criminal liability is a bit different. Again, the criminal liability, the ILO, on numerous occasions, has raised issues with this, especially regarding the crime of business interference. Now, the ILO, being an international organization, uses a lot of diplomatic rhetoric in its expression of concerns or whatever. But then now, for the Penal Code Article 314 of the Criminal Act of Korea, the ILO has directly called for the abrogation of this article. So it is a sign that the ILO sees this as a very serious matter. And the crime of business interference in Korea, I understand, is also a subject of concern and monitoring in the U.S. as well. So for criminal liability, I believe that the court's attitude also has to change. And then about the collective bargaining between the principal employer with the trade union of a subcontractor. Now, as was mentioned earlier, this case is still pending at the court, but now, basically, for the subcontractors, even if it's subcontractors' employees, for them to engage in collective bargaining with the employer that has influence or control over their working conditions, I believe is a given. So we also need to have the kind of legal attitude that would allow that as well. And last is about the meaning of the interpretation by the ILO monitoring bodies on the Convention number 87. Now, since it has been ratified already in Korea, now it can be directly applied by the judges in their decisions, or it can also be indirectly used by the judges when interpreting the domestic labor laws. So the domestic labor laws can be interpreted in the way that would be in conformity with the convention. Now, having said that, for the direct application of number 87, its provisions are quite abstract, so it is highly difficult and highly rare that we are able to use these provisions to resolve disputes. So I believe that a more likely application would be the indirect application, meaning that we can apply this for interpretation of the domestic laws. And then, in such a case, then we must respect the accumulated knowledge and expertise of the ILO supervisory bodies, and for the courts to seek the way that would make it possible for them to interpret the domestic laws in line with the convention. Again, the issue here is that the supervisory body's interpretation is, officially speaking, the supervisory bodies of the ILO do not have the authority to give the interpretation, meaning that the supervisory body's interpretation is not legally binding. But as we can see from the name, supervisory bodies, we need to have the interpretation of the convention to implement and to monitor the implementation of the convention. So for the ILO supervisory bodies to provide interpretation is part of the given as part of the convention. And also the ILO supervisory bodies have accumulated a high number of interpretations for over 70 years, and we must also respect their authority. So I believe that it is only reasonable that we do respect their interpretation. And also the ICJ, especially for the CCPR, so the ICJ places great weight on the interpretation or the opinion of the expert panels like the CCPR. So given also this reality, then again, although legally it is not binding, the ILO supervisory body's interpretation does have significant authority. And recognizing this, I believe that it is also necessary to more actively reflect them into the court's decisions. Now, in order to apply the supervisory body's interpretation to the court's decisions more actively, then the Korean judges and the legal experts must also have an accurate understanding of such interpretation. And to do that, having seminars or meetings like we are today, and also study meetings would be necessary to understand the purpose and the content of the Convention number 87 and to learn about the legal precedents involving this convention. So we need to have the kind of education, training, or seminars on a regular basis for the judges and the legal experts so that we can also enhance understanding and awareness of the freedom of association in Korea. That is all for my presentation. Thank you. Thank you very much for the presentation. So Professor Lee talked about the state's duties following the ratification of the number 87 convention, talking about the duty to protect, promote, and realize. And he also listed the specific duties of the legislature, the executive, and the judiciary. And moving beyond that, he also talked about some of the areas of improvement for the courts in order to help realize the convention in Korea. So thank you very much for that.
Let us go on to the panelists. Let us listen to all four panelists before we go back to our speakers. Due to the time constraint, we would like to ask each panelist to limit your comments to 6 minutes. First, let us invite Ms. Karen Curtis, the Chief of Freedom of Association Branch of ILO.
Thank you very much, and I hope to be relatively brief. I'm going to sort of divide the discussion points with Mr. Baudonnet, who will also focus more on the collective bargaining issues that have been raised. In the first instance, of course, I want to really appreciate that both of the presenters have focused so much on the ILO Committee on Freedom of Association, using the compilation. I can, while of course their English is excellent, I can tell also that the translation of that into Korean was an excellent initiative in Korea. But I would like to add something in terms of the compilation to put it in context as well. If you read through this compilation of decisions, you have sort of most instances, very short paragraphs that set out a kind of a principle applied to a specific situation. And sometimes you will see one decision that seems to be very different from another decision that you might read later on in that compilation. And that's because the Committee on Freedom of Association, of course, they make these decisions when they examine cases, so very specific cases in a specific case context, which may not necessarily be relevant to Korea. So on the one hand, there are the broad principles that you can look at and say, yes, this is very important and we need to ensure this. And then you may come across something that you wonder, would that be possible to apply in Korea? The electronic version of this compilation enables you to immediately go into the case that actually gave rise to that specific decision, or the cases. Sometimes it's used in many, many cases. That can be helpful both to see whether it makes sense to Korea, but also to see whether it's something that was said to many different countries across the world with many different socio and economic contexts, but still repeated that, for example, the one issue that's raised time and again today, self-employed workers should have all the 3 rights that are available in the conventions. So I just wanted to mention that and to also encourage you to go to the online version if you wish to get into the context of each particular decision that was made. And so in that respect, to say that I think one of the issues I wanted very much to pick up is this question of criminal and civil liability. The fact that we are seeing scenarios where either because a strike is seen as not being legitimate, because somehow not covered by the law, or where damages are being seen. So if we look at Section 314 of the Penal Code, and we have the excellent and welcomed decision of the Supreme Court to really try to reduce the cases where that would be applied to illegal strike action, but that the committee still felt that there was a need to go further. There, just to say, of course, that is something where the judges can decide to really look at the case. Is there actual physical damage? Was a fence torn down? Was there something that actually needs to be compensated? Or is it a abstract notion of damage to the production, that indeed the enterprise was not producing a certain amount. And this is where we see ourselves moving into these very, very large civil liability claims. And so there, what I've heard today about the judicial restraint in applying such hefty damages with excessive amounts and intimidating effect. So that's something where there really needs to be movement towards more and more restraint from the ILO. Coming to Professor Lee, thank you for citing the Reliable Compass in Any Weather. This is a publication that came out for the 70th anniversary of the Committee on Freedom of Association, 70 years, over 3,400 cases it has examined, and where we hope very much that the compilation is also very useful. I wanted to just pick up there the important point you made about the establishment of social and cultural foundations for freedom of association, for collective bargaining, and that this is something all of the freedom of association conventions and collective bargaining conventions work towards, this question of promotion. And to promote, you need to promote that climate also that recognizes the importance of collective representation of workers to balance the power in labor management relations, and the use of that through collective bargaining, occasionally through strike as a last resort, but not necessary if you really have that climate of dialogue, collective negotiations, that really functions in an inclusive dialogue. So those were just the couple of points I wanted to pick up. Thank you very much, Judge Kim. Thank you.
네, 토론 감사드립니다.
Thank you very much for your comments.
뭐 특히 이게 피부에
I do believe that the comment that you have made about the compensation as well as the excessive compensation and the criminal and civil suits that are raised related to these compensation are things that judges must keep in mind, as you have mentioned, and creating a social and cultural foundation, and this being translated into the importance of having collective representation is another point that we must keep in mind.
자베르 보도네.
Next is Mr. Xavier Baudonnet.
Thank you so much. And yes, thank you to our presenters for their two really excellent presentations. So I will briefly address some elements related to collective bargaining that is recognized by Convention 98. So I noticed that both presenters mentioned some possible existing restrictions concerning the scope of collective bargaining, both from a personal point of view, which types of workers can bargain collectively currently in the Korean legal context, and also concerning the content of collective bargaining, the subject matters that can give rise to collective bargaining. And I think you very interestingly addressed these issues, mentioning that now that Korea has ratified Convention 98, that Convention 98 is part of the domestic legal order of your country. The judiciary could certainly take into account Convention 98 and the way it is understood and interpreted by the ILO supervisory bodies to interpret your domestic legislation in light of the convention. So that is certainly very interesting. It is very much related to what was said yesterday. And on this, I would like just to recall, I just need to find the, I don't know if I have the small, thank you. Yeah, would like just to remind a little bit some elements, very general elements, but still I think quite useful elements about Convention 98. So we know that Article 4 of Convention 98 requests the ratifying states to promote voluntary collective bargaining between employers and workers. And this means that the domestic legal order should therefore create an environment conducive to the development of good faith collective bargaining at all levels, rather than restrict it. So actually, since you have talked about a series of possible restrictions to the personal scope of collective bargaining, to its content, to the different levels where it can take place, and you have also mentioned, and I think all presenters and also Karen Curtis, and also this morning it was also mentioned that the actions that may be taken by some actors to request their right to collective bargaining can give rise to sanctions. So all these elements could be or should be assessed in light of the broad obligation to promote collective bargaining that is now part of your domestic legal order through the ratification of Convention 98, and actually also through your constitution, because we understand that your Article 33 that recognizes collective bargaining is very much in line with the content of Convention 98. So certainly here there is room for an interpretation of the domestic legal order that would be consistent with this obligation to promote collective bargaining rather than restricting it. I will not enter into details about the specific aspects that were raised by the presenters about possible restrictions on the scope of collective bargaining. I think it was already very much well explained, and there were many mentions, many precise mentions to the supervisory body's comments. But of course, we know that there are some specific cases that are very important here. For instance, case 2602 about the right of self-employed workers to have access to collective bargaining. You have also mentioned the issue of the content of collective bargaining, which subjects could be excluded from the negotiable issues. And here you have important elements on the 2012 General Survey on the fundamental conventions, so I will not enter into details about that. You have mentioned the issue of time off. It was also mentioned this morning. There is, I think, also an important observation from the Committee of Experts last year about application of Convention 135 that once again highlights the importance of ensuring that workers and employers can negotiate freely this issue. And with respect to some contracted workers, of course, we have the cases 1865 and 2602, but you have all mentioned this. But all these elements are elements that, of course, could be particularly useful for the judiciary with a view to interpreting their domestic legislation in light of Convention 98. But beyond the issue of the judiciary, which is of course very important, there is also what my colleague has mentioned about the importance of social dialogue. And actually, while many of the elements highlighted by the supervisory bodies may be extremely useful for interpreting and implementing your legislation, there are also in these comments a call for social dialogue, a call for making sure that the government, the unions and the employers sit together and find solutions to the problems that have been explained by our panelists. And in some cases, this social dialogue is very, very important because sometimes you have to think outside the box. For instance, concerning the possibility for self-employed workers to bargain collectively. Probably the way collective bargaining for self-employed workers can take place is not exactly the same as traditional collective bargaining. So on this, there is nothing better than social dialogue to make sure that new solutions and adequate solutions are found to give a real possibility for collective bargaining for this category of workers. So importance also of social dialogue, as it was already mentioned. And finally, I had two questions for our panelists. One question has to do with the concept of mandatory collective bargaining versus voluntary collective bargaining. So because if I understand correctly, in your system, there is mandatory collective bargaining, which is okay with ILO Convention 98. It is absolutely acceptable. But we understand that if an employer does not enter into collective bargaining in the context of mandatory collective bargaining, there may have some series of consequences and possible sanctions. So my question was whether, in addition to mandatory collective bargaining, would there be, in your current legal system, room for voluntary collective bargaining, the request of which could perhaps give rise to legal industrial action? So since we understand that the issue currently would be to extend collective bargaining to new situations, new categories of workers, would there be a possibility to use voluntary collective bargaining as a tool to extend collective bargaining? That's my first question, and my second question will be much briefer. It is about collective bargaining at the sectoral level. My understanding is that in your current system, most collective bargaining takes place at the enterprise level, which may give rise perhaps to some difficulties in situations where there are different companies working close to another. So this is the issue of subcontracting workers in particular. Many countries are addressing this issue through sectoral collective bargaining. So is sectoral collective bargaining possible in your current legal system, or what would be necessary to perhaps better promote and make possible this bargaining at that level, bearing in mind that under Convention 98, collective bargaining should take place at all levels? Thank you so much.
네.
Thank you very much. So he talked about the collective bargaining focused on the number 98 convention, and then he also raised two questions to the two panelists, and I hope that the two panelists will prepare their questions, prepare their responses to the questions.
Next, we would like to turn the floor to Attorney Kim Yong-mun.
네. 안녕하세요.
Good afternoon. I am Kim Yong-mun of Dentons Lee. Thank you very much for your presentations. Thank you to the professors and judges for your presentation. As a lawyer, I usually participate on the side of those who are fighting their issues at court. And these are issues that we're discussing today that I come into contact in my everyday work. And so I do believe that it was very useful to my work. And I would like to listen to the opinions of the speakers on the following topics. First is the self-employed workers' right to organize, especially workers in special employment types. The presenter seems to suggest that it is in line with ILO standards to allow the establishment of unions in principle for workers in special employment types, referring to the advice of the ILO Committee on the Freedom of Association, that in the case of agricultural workers, self-employed workers in general, and those who practice liberal professions, they should nevertheless enjoy the right to organize. In Korea, the concept of workers is somewhat distinguished in the Labor Standards Act and the Labor Unions Act so as to more broadly recognize the concept of workers in collective labor management relations. Since a distinction is based upon the precondition of bilateral relations between a worker and an employer. But I do believe that the basic distinction between the labor provider and the labor receiver is the precondition to all of these laws. And therefore, self-employed workers who do not belong to any specific user are structurally excluded from the application of the Trade Unions Act. So that is the structure that we have at hand. Also, the spectrum of labor provision types is so diverse and variable that even if legislation is created on matters related to the employment status of workers in special employment types, it is expected that cases in which the employment status is difficult to interpret will arise constantly. So because of the changes in technology, new types of labor will continue to rise, making it difficult to cover all employment status with specific laws. And so regarding areas with substantial room for variations like this, it would be more efficient and practical to resolve individual cases through the flexible interpretation of individual courts rather than regulating all matters via written law. I do believe that that would be much more efficient and practical. Next, let's talk about disqualifying non-workers from being elected as union officials. The presenter pointed out that the amended Labor Unions Act, which restricts the qualification of officials of enterprise-based unions by union members who work for the relevant company only, runs counter to the recommendation of the ILO CFA. Basically, it is necessary to maintain the consistency of the principle of union autonomy regardless of non-enterprise level trade unions and enterprise-based unions. It is questionable whether there is any clear reason or inevitable circumstances that would require restricting the qualification of union officials only at a time when non-workers, including the laid off and unemployed, are allowed to join enterprise-based unions. Small and medium-sized enterprises whose independent power is relatively weak may need the participation and support from non-workers more desperately. Considering all of this, I agree with the opinion that it is undesirable to disqualify non-workers from being elected as officials of enterprise-based unions. Nevertheless, ILO conventions are abstract norms that present principles and directions only and are unable to exclusively regulate individual countries' particular or specific circumstances. Therefore, even if some particularity of Korea's labor management relations is partially reflected, I do believe it is somewhat excessive to consider it as a violation of the obligation to respect, promote, and realize ILO conventions. In this regard, as Professor Lee Sung-hoon has mentioned, if the obligation to realize the freedom of association is translated as including not only legal and systematic improvements, but also the establishment of social and cultural foundations, it would be so comprehensive and abstract that it would rather weaken the normative power of the ILO conventions. So if we have a comprehensive approach of including the establishment of social and cultural foundations, although I agree with this direction, may weaken the normative power of ILO conventions. Next, let me talk about the prohibition on the remuneration of full-time officials of trade unions and the time-off system. The ILO has recommended to abolish the article stipulating the prohibition of remuneration for full-time officers of trade unions, citing that the issue of remuneration for full-time officers of trade unions is not subject to a country's legislative intervention. In consideration of this, the amended Trade Unions Act maintained and supplied the time-off system and abolished the articles that banned remuneration for full-time officers of trade unions. Regarding this, the presenter suggested in his report that although the basic position of the ILO is that decisions made on the salaries of full-time officers of trade unions should be left to the free and voluntary negotiations of relative parties, the current system has been making strong legislative interventions by nullifying any agreements that exceed the time-off limit and by limiting the types to utilize as being subject to the time-off system. This is something that I basically agree with in principle, but autonomy in labor management relations should be respected, definitely. However, considering the reality of labor management relations in workplace, there may arise no small number of side effects accompanying such unlimited autonomy. Hence, introducing the time-off system in order to reduce the gap between ideals and reality will be inevitable for efficiency's sake. The ILO recommendation stipulating that the issue of remuneration for full-time officers of trade unions is not subject to a country's legislative intervention and should be left to the free and voluntary negotiations of relevant parties can be viewed as implying that a trade union should maintain economic independence from its user. In this respect, in the case of Korea, in particular for the trade unions of small and medium-sized workplaces, if a user completely refuses to allow the time-off system, it may become very difficult for trade unions of small and medium-sized workplaces with little independence to practically exercise their bargaining power. And so we need to make sure that this is used as a supplementary measure. As for labor management in practical settings, the time-off system serves as an important guide, inducing the minimum economic support necessary for union activities. So by inducing the minimum economic support necessary for union activities, it could partially supplement the freedom of association. I understand that we are quite a bit behind schedule, so I will end my discussion at this point in time.
예, 감사합니다.
Thank you very much for your discussion. You did point out your comments on 3 different topics. If the presenters wish to comment on these 3 topics, we will get back to you after all of the panelists.
토론 듣도록 하겠습니다.
Now next, let me move on to senior researcher Erim Yoon. Yes, hello. Now, after ratifying the numbers 29, 87, and 98 conventions of the ILO last year, and then they go into effect this year, it is true that there have been quite a lot of expectations. At least, perhaps, the state's attitude regarding these conventions and their provisions would change. But to put the conclusion first, and I would say that our reality has not changed at all, and perhaps we're taking backward steps. Now, before ratifying the Convention on the Freedom of Association, then now whenever there were infringement cases and whenever there was the Freedom of Association Committee's comments regarding such cases, then the Ministry of Employment and Labor would always respond that their comments and their recommendations are not legally binding, and since we're not a ratifying party, it has no effect on us. And then now, afterwards, after we have ratified them, now this is also what the government has said. So after we ratify these conventions, then it also says that the right to collective bargaining or the freedom of association, they are not specifically stipulated in the conventions. It's just that from the supervisory bodies, they have explained these rights through the recommendations or interpretation. So in other words, the government is still not fully respecting the conventions and their provisions. And then also more recently in the truckers' strike, the government also issued the back to work order. And then now the international labor organizations, we have requested the involvement of the labor organizations from the world to intervene in this, as they are violations of the conventions. And the ILO also sent a letter to Korean government. And there was once again explanation about the supervisory body's recommendation to fully guarantee the 3 labor rights and for the government to comply with them. But again, the Korean government to the ILO's letter, what it said was that it is just the ILO expressing its opinion, and in terms of the infringement of the 3 labor rights in Korea, the ILO has not meted out any judgment or decision regarding the situation. So the simple thing to do for the Korean government is to disclose the letter. And even the National Assembly woman, Ko Min-jung, has asked the government to open up the letter. But then the government said that this letter is related to the state's national security and diplomacy, and disclosing it would be detrimental to the national security, so it is not disclosing the letter. Now, there are a lot of controversies regarding the ILO's letter, and if, as the government argues, it is just about its recommendation, or if it's just about its opinion, then the government can simply open it up. But instead of opening it up, it is hiding it and then keep saying that it is just a matter of opinion. Now, the ILO, including the Freedom of Association Committee, so the ILO supervisory bodies, including the Freedom of Association Committee, I would like to list the recommendations that they have given to Korea over the years and how the Korean government has repeatedly ignored them. So, for example, regarding the definition of a worker. Now, according to the convention, it is worker, and the ILO supervisory body's consistent interpretation is that worker who is subject to numbers 98 and 87 conventions, then they have nothing to do with contractual status. In other words, even the self-employed have the freedom of association and the right to organize, so, and also the right to collective bargaining. So all these rights should be guaranteed to them, has been the consistent opinion and finding from the ILO supervisory bodies. But then now another issue is about the 2602 case, and this also has been a specific issue in this case as well. But now let me cite the case of the truckers' strike. Now, in the morning, the Ministry of Employment and Labor mentioned that regarding the truckers' union, they are not denying their freedom of association. It's just that legally speaking, they are not a union, so that is why they are not entitled to the protection under these conventions. But again, it is this kind of interpretation that is in direct contrast to the ILO's interpretation. As I mentioned earlier, now their recommendation is that a worker is not limited to the contractual relations, and also the Korean Supreme Court's definition of a worker is also quite broad. But again, in the case of Korea, using the declaration system as the weapon, they have a lot of discretionary power in union registration. And also, they are saying that since the truckers' union is not a union, if they were to go on a strike, then automatically this means that they are on an illegal strike. And that is why it has been repeatedly observed that this is not in line with the conventions. Now, let me also clarify one thing. The truckers' union did make the declaration. Now, when it was formed in 2002, it was part of an umbrella organization. So it was an umbrella organization under the KPTU. So because this is an organization under the umbrella of the KPTU, it does not have to declare itself as a union. So now then, if I were to accept their argument that because it did not declare itself as a union, it is not a union yet, but we can still refer to the Supreme Court's decision where it said that extra-legal union in and of itself does not mean that they're not a union. But still, so that is the fact of the case 2602. Now, in 2009, the government, regarding the KPTU that was trying to organize the truckers, now the government said to the KPTU, since you are trying to organize those who are not legally workers, unless you stop your activities, then we will withdraw your registration as a union. So it is actually the government that is violating the 3 labor rights, and that is why the case 2602 was raised. And you see that this action has been repeated many times. And again, if I were to accept the government's argument and admit that the truckers union did not even go through the legal procedure as a union, so because she mentioned that it did not go through the mandatory mediation. So now let's say in this case the truckers are calling for the compliance to the safe rates that the government has committed to. Now what if they went to mediation with this issue? Then the Labor Relations Committee will say that this is not part of the content of the collective bargaining, and this is not for mediation either. So they would have been precluded from being able to engage in collective bargaining with regards to safe rates under the Trade Union Act. And then also in the 1862 case, now there have been the recommendations from the ILO several times. So again, this is about the construction workers, and this is the construction workers of subcontractors trying to have collective bargaining with the principal contractor. And this is also the act that should be protected because they have the de facto control. But then, because there is no direct employment relations between the principal contractor and these workers, and for them to engage in collective bargaining, then this would be entitled as the crime of coercion or crime of threat, as was also found by the Korean courts. Now, in the morning session, it was mentioned that if we are to broaden the definition of the employer under the TUA, then this would also be related to the principle of no law, no penalty. So this could also cause confusion in the legal order. But then I would like to flip the question. So if you can be subject to criminal punishment for calling for collective bargaining, well, actually, how many such cases did occur? As far as I understand, it was only once. So in reality, what happens is that the workers are calling for collective bargaining for the employer that has de facto control on them, and in such cases, then they are found guilty of the crime of coercion and coercion of threat. And also in such a case, then although this is not a violent strike or this is not a destructive strike, they would still be held liable for holding unlawful strikes. So for this, what I would like to say is that more than anything else, now for the numbers 87 and 98, and also for them to have the same effectiveness as the national laws, what this means is to make sure that they are implemented properly in Korea. And as was also observed by the ILO, for the collective bargaining, we also need to make sure that there is guarantee of de facto right to collective bargaining. So I fervently wish that now in September 2020, from the en blanc decision by the Supreme Court, it was mentioned that the three labor rights are natural rights, meaning that even without any laws, they should be guaranteed as natural rights. So that was a decision by the Supreme Court. So I do hope that the self-employed workers and the specially employed workers, I hope that they will not be subject to punishment or be restricted with the TUA for trying to engage in collective bargaining with the de facto employer, and because that would be against the Korean Constitution as well. So in line with the spirit of the conventions that we ratified and also in the spirit of the Constitution, I do hope that there would be exemption of civil liability as well as the criminal liability. Thank you very much.
네, 감사합니다. 지금
Thank you very much. So we have talked about the hot issue of the cargo trade union. During the morning, we have heard a presentation from the Ministry of Employment and Labor, and it has been mentioned. We have listened to all four panelists, and we are behind schedule already. Presiding Judge Kim, you will be joining the final plenary session, correct? And so we will leave your comments for the plenary session, but Professor Lee, you are not to participate in the final plenary session. And so we wish to listen to Professor Lee as well as the two participants from ILO, because senior researcher Yoon has mentioned the ILO. So maybe if there is anything that you would like to mention, as the three of you will not be participating in the final plenary session, we would like to turn the floor to you. First, Professor Lee.
일단 질문 두 가지.
Well, now, first of all, there were two questions, I believe, so I'd just like to provide my responses to the best of my ability. I would say that that is in keeping with the order of things. Now, first, about the mandatory collective bargaining, yes, the employer does have the duty to engage in mandatory collective bargaining, but then now for the voluntary collective bargaining, does the employer also have to engage in that? And is it also possible to have voluntary collective bargaining under the Korean legal system? The answer is yes. So yes. So on one hand, there is the mandatory collective bargaining to which the employer must oblige with, even if it does not want to. And then for the voluntary collective bargaining, so if the employer agrees to the collective bargaining, then yes, there is such a system of voluntary collective bargaining as well. And then now, second, about the sectoral or the occupational collective bargaining. And so I believe that this is pertaining to the single collective bargaining window. And perhaps it is impossible in Korea to have this kind of sectoral collective bargaining. Well, now in the case of Korea, we do have the single window system, but for the sectoral collective bargaining, we also have a lot of them. For example, in the metal industry, healthcare industry, finance industry. So in these sectors, we do have the sectoral collective bargaining. And also what the attorney has asked about, so for the social and cultural foundation being built, and if we are to also include that as the state's duties, then wouldn't it weaken the normative power? Well, these duties, I would say, are, well, as Ms. Curtis also mentioned, now this is part of the broad obligation of the state. So not the judiciary, but for the state, for the executive and the legislature. So for them to respect so in trying to respect the freedom of association, it also has to create this kind of environment. It's not for the judiciary to create the socio-economic environment conducive to the freedom of association. Again, this is for the government, for the executive and the legislature. So for them to create the social and cultural foundation that is conducive to freedom of association. So even if they do have such duties, does not weaken the judiciary's normative power or their power to make decisions. So that is all for my answers. Thank you. Then perhaps from either of the ILO representatives, what researcher Yoon has talked about regarding the truckers' strike, anything that you would like to say?
Well, I guess, I mean, it will always bring me back to the same question, and I guess perhaps the principal question of being subjected to civil and criminal liability, to have a labor relations framework that does not enable groups of workers to organize and exercise their rights in a way that they are not subjected to the possibility of damages that are economic in nature, that I understand are being calculated with respect to the economic impact, and yet we know that the right to strike is a question of economic impact. That is the reason for a strike. That is the way of changing the balance of power in the labor relations to be able to negotiate decent wages or a fair wage rate here. So that's something, I guess, what I'd be very, and for another time, for the final session, but it would be interesting to know how often industrial action finds itself with charges being brought on criminal and that they're not violent, non-violent, not destruction of property, but simply the basis of damages. How often are such types of cases brought, and how are they dealt with, and how long does it take to deal with such cases? Because I understand you may have still pending before the courts cases from 2009. And this, of course, is extraordinarily damaging to the trade union movement, potentially in a global way, and to freedom of association. So I think that that would be the only point. The only other one I wanted to raise was concerning the time off system for full-time union officers, and just to understand if it's no longer banned, which is the change that the government made to the legislation, why is paying more than the time off table that's provided, why is paying more than that sanctioned? But that's a question perhaps also for the end, because I didn't want to add questions to the end of this particular session. Thank you.
Yeah.
Yes, please go ahead.
Concerning the issue of voluntary collective bargaining, part of the question was about also to know whether is it possible for a union to take industrial action to request for voluntary collective bargaining, and whether this industrial action would be legal.
여기 뭐 판사님들.
Well, we have a lot of judges here, so, but then the judges, I'm sure, are not willing to respond right now. So if I may respond to the question to the best of my knowledge, then now regarding the business management decisions, then they are not subject to collective bargaining, but they can engage in voluntary collective bargaining. But then what you're asking is that now let's say if the collective bargaining fails, and then if they go to collective bargaining, then will this be lawful? Well, regarding that, there is no Supreme Court decision that has specifically judged or that has specifically ruled on such a case. But then, if I may personally take a guess, then if it were to go to the courts, then I believe that the court, now as part of the purpose of the industrial action, the legitimate purpose for industrial action should be the subjects of collective bargaining. Given that, then, now if it is about business decisions, then they could have voluntary collective bargaining, and if this fails going into industrial action, in such a case, then it is highly likely that it will be found to be not justifiable. All right, then that issue, I believe, is an ongoing one. And then now with this, we can conclude session 4.
We had 2 presenters and 4 panelists. A big round of applause for all of them, please. Thank you.
Participants of session 4 for your thought-provoking presentations and discussions on our topic. Please give a big hand of applause once again. This brings us to the end of session 4. We will now recess for 20 minutes and reconvene at 3:40 p.m. Please enjoy a break. Thank you. Distinguished guests, the final plenary session will commence in a moment. Please enter the conference hall and take your seats. Moderator and panelists of the final session, please come up to the stage and be seated in your designated seats. Thank you. 내외기빈 여러분, 종합토론 세션이 곧 시작될 예정입니다. 행사장 밖에 계신 분들은 조속히 행사장 안으로 입장해 주시길 부탁드립니다. 종합토론 세션의 좌장 및 토론자 분들께서는 무대 위로 올라오셔서 지정된 좌석에 착석해 주시기를 부탁드립니다. 감사합니다. Distinguished guests, the final plenary session will commence in a moment. Please enter the conference hall and take your seats. And I would like to invite moderator and panelists of the final session to the stage and be seated in your designated seats. Thank you for your kind cooperation. Now, it's time to proceed to the final plenary session of the conference. Honorable Justice Sun-Soo Kim will once again lead this session as a moderator. Please welcome him with a big round of applause once again. Justice Kim, now the floor is yours.
네, 안녕하십니까.
Good afternoon, ladies and gentlemen. Now, following session 4, I have the distinct honor of once again serving as your moderator. Now, for 2 days, we have been discussing the international human rights and labor standards challenges for the judiciary. So we have been hearing from the various experts on the different issues of the labor laws and the labor rights. In particular, the issues that could potentially arise out of the ratification of the conventions in Korea. So we were able to also shed light on those potential issues as well. And following all the presentations and the panel discussions, we now will have the final plenary session, and allow me to have the honor of introducing the panelists. Now first, we have Mr. Tim DeMeyer, Senior Advisor of the ILO. Please welcome him with a big round of applause. And then we have Ms. Rafaela Milena Kuntz, Junior Fellow of the Collegium Helveticum. And we have Judge Dong-hyun Kim, the presiding judge of the Seoul Central District Court. And from the Ministry of Employment and Labor, now Mr. Chang Jun-kwon, who was scheduled to be here originally, we have in his place Director Hwang Hyo-jung of the Labor Relations Legal Affairs Division. And also now in session 4, we had Attorney Yong-mun Kim as the panelist, and he is once again here with us from Denton's Lee. And we have Senior Researcher Erin Yoon from the Seoul National University Law Research Institute. Now in session 4, we have had the presentations followed by questions and answers. But because of the time constraint, we were not able to give enough time to respond to the questions. So I would like to go back to Judge Dong-hyun Kim to respond to the questions raised in the previous session. So why don't we kickstart with Judge Dong-hyun Kim.
그럼 제가 먼저 몇 가지 말씀.
Thank you very much. I would like to start the plenary session. We did discuss various points during session 4, but I was not able to answer to the questions. Concerning the questions by Ms. Karen Curtis, I would like to share with you the answers to the best of my knowledge. Ms. Curtis talked about the criminal and civil liability, particularly related to strikes. In 2011, according to the Supreme Court decision, we have seen a sufficient decrease in criminal liability, especially when I wrote the report for the JPRI. I was able to analyze many of the relevant judgments, and we have seen that during the last 4 to 5 years, there has not been any de facto criminal liability that was held against any strikes. Ever since the report was published, there is updated data, and I looked at that data before this conference, and there are a few cases in which the parties have been found guilty. And so when I wrote my report for the JPRI, I thought that it was at a level where criminal liability was no longer an issue in our country, but actually this issue is rising again. And so judges and practitioners should certainly take a deeper look into this issue with interest. And this is an issue with a large gap compared to the ILO international standards. And so it's an issue that we need to certainly make efforts for. When we take a look at civil liability, well, there are more number of cases related to civil liability compared to criminal liability, to the best of my knowledge. And if you take a look at the size of the suits, it is very large. And it can, in fact, intimidate the activities of trade unions and also work against the activities of trade unions. I think this is quite a sensitive and complex issue. For illegal acts, we can't say that they should not be held accountable for compensation, because that actually denies the concept of private property. And so for illegal strikes, And if there are damages due to illegal strikes, we cannot say that there should not be any compensation for such damages as a legal professional. But if we take a look at the judgments by the Supreme Court, the scope of recognizing illegal strikes may have been wider than necessary. And so for the trade unions, they may have believed that it is legitimate, but that legitimacy is recognized in a restricted manner. And so what we need to do is to widen the scope of legal acts of strike. And when we take a look at civil liability for strikes, we need to apply the theory of the abuse of power and also the limitation of the damages. And if we take a look at the foundation for these concepts, when the employer asks for civil liability, the employer does not actually expect to receive the full amount that is being asked for. So we need to take a look at the intention of the employer. So if the employer intends to intimidate the trade union and hinder the activities of the union through this civil liability suit, we need to take that certainly into consideration. And I believe that that is on par with the concepts of civil suits. And so when we think about civil liability, this is certainly an issue that we need to look into. And Mr. Kim Yong-mun talked about special employment, and in particular the self-employed workers. And he talked about the expansion of the right to unionization. Dr. Yoon talked about how there are not many cases where the illegitimacy is recognized, but I do believe that this is the same for the right to unionization. Those who interpret the law, in particular judges who make such interpretations, it's very difficult to think about the legitimacy of criminal punishment for illegal strikes. There are not many countries around the world who recognize this. For example, if there is an objection to collective bargaining, is that directly a legal form of trade activity? Especially the issue of expanding the right to organization and the right to association. We have to take a look at the legal relations between the worker and the employer. And if the legal relations is not clear, and we have criminal punishment for objecting the collective bargaining, then that actually is an issue that judges must keep in mind. And so the expansion of the right to association and the right to collective bargaining is an issue that we have to take a look into in relations to the illegal strikes. And maybe Dr. Yoon would have some complaints related to this, but as someone who interprets the law, that is an issue at hand. And because this is the last opportunity that I have to speak, probably, I would like to add one or two points. And this is something that Ms. Karen Curtis had asked that I speak about concerning the remuneration and the time off for the union workers. Well, these are issues, for example, remuneration is not prohibited in written law, but there are no practical changes even with the omission due to the amendment. I think criminal punishment that remains a possibility within the written law is actually the biggest issue at hand. And so criminal punishment is something that we have to take a look at from a legislative perspective. I would like to add one last point. having studied labor laws, in particular ILO conventions, what I found is that there are so few people who study labor issues and ILO within the the jurisdiction in Korea. And so most of the papers are written by academics. Sometimes some attorneys write papers. But we also need to reflect the perspective of judges related to labor laws and ILO conventions. So if we do not abide by the international labor standards set by the ILO, then what kind of a result will we have? That is the limit to the statements by judges. And some judges also talk about policy level issues. But I believe that the perspective and the role of a judge is to discover what is actually a law. So practical issues, for example, this is true for all international law, but international labor standards is very difficult to enforce. Other than judges, I think they would think more of enforcement measures, but because it's difficult to enforce, some people believe that we can take these standards lightly. But for judges, once it is deemed to be a law, there is a mandate to abide by that law, whether or not there are enforcement methods, and courts need to guarantee compliance with this law. And so the position of judges and other legal professions, as well as people in the academia, may be different. So if you wish to change the reality, and if you believe that the reality is not fair to all those involved, we need to think about what is a law. And when we think about what is a law, then it could contribute to the understanding of judges. That brings me to the end of my comments. Thank you very much. Well, the order that we will be speaking for the plenary session is as follows. Since everyone participated already as presenters or panelists, if you have anything to add to your particular session, then we would like to give you that opportunity and also give you an opportunity to talk about the overall conference. And we will also like to give you an opportunity for discussions with the audience.
Now then, in session 1, there was discussion by Mr. Tim DeMeyer, so I would like to ask him to present his comments.
Justice Kim, and let me first of all thank all of the speakers for what I think was an extremely rich and inspiring conference. I've had the privilege indeed of coming to Korea since about 30 years, and it is impressive to see the change over time. Not just with respect to the depth with which the issues are being examined, but I think also in terms of the audience. We see that the interest is widening. I think we're very clearly seeing a powerful signal from the judiciary saying we are ready to consider international human rights law, international labor standards, and that means not just the indeed rather abstract provisions of the treaties, but also the understanding that the various treaty monitoring bodies and the supervisory bodies have attached and continue to attach to the various provisions. But I think also this is certainly something that struck me with a lot of pleasure. We see a young, interested audience with a significant number of women. And we have spoken not much, I don't think, about the issue of gender equality, but I think in terms of the challenges going forward for the world as a whole, and I think also for Korea, I think the issue of gender equality is probably one of the most significant to look into, and I'll say a few things more about the challenges. But I think that is particularly encouraging for us to see. So my main takeaway, if you wish, on this reflection on the role of the judiciary, the challenges of the judiciary with respect to be more responsive to the requirements of international human rights law. If I would have to summarize it, and I'll do this at my own peril, obviously, would be that what I heard all of the speakers say is that, yes, we have to respect, still, we are a legal system where we respect the separation of powers. And I think Justice Kim just mentioned it once again. There's no need, probably, no particular urge at this point in time to substitute the judiciary for the legislative. But at the same time, we can and probably we should use to the full our interpretative powers in the judiciary to see how we can make the best of Korea's constitutional order and its very developed legal system to make sure that it is closer aligned with international human rights law that at the end of the day, of course, also to a large extent reflects the good practices of a significant, indeed a universal composition of the world's nations. And my second point would be maybe that the logical conclusion would be, and we spoke about this at some length yesterday, self-executing nature of international law. There's a little bit of hesitation around this, and I think for good reason. It was mentioned a number of times today. A lot of there is abstract, so maybe not all of international human rights law lends itself perfectly to considering whether they are self-executing or not. But maybe the correct way of doing this is by correctly understanding and seeing the broader picture, if you wish, understanding the identity of Korea's constitutional order. And this is important, because if you look at the constitutional order, which is an order that has its own history and it has known its own struggles, as I also mentioned yesterday, there is a very clear commitment to democracy. There is a very clear commitment to market economy, to the laws of supply and demand, to open economy that values property rights. It was mentioned, but of course, with property rights, the value of property rights is the ability to be efficient, to be innovative, and eventually to create wealth. There's respect for human rights. The right to property is one human right, but as we all know, as we've said, human rights are interdependent, interrelated, and therefore at all points in time there needs to be a correct balance found, depending on the economic relationships and the economic power relationships that exist within that constitutional order. Respect for the rule of law, respect for separation of powers. And so it is, I think, that, and I would like to come back here, that when this reflection is made within particular cases around what the constitutional order is and how we interpret that and how we interpret laws that derive from that order, I'd like to go back to the opening remarks that we heard yesterday. The role of the judiciary really is to rule with foresight and fairness. I come back to it time and again because I think that's extremely important. Why? Because we also need to, as lawyers, I think, at times be humble. We need to recognize at times also the limitations of our own discipline. As lawyers, we are trained to look backwards. We operate on precedent, we operate on statutes that are being adopted in the past. We often ask ourselves questions of hierarchy. Well, what is higher and what is lower? We tend to categorize. We spend a lot of time thinking about does this particular situation fit this particular category or that particular category? What is the definition? What is the definition of employer and worker? We came back to it so many times. And in many cases, when one considers human rights, that is a limitation. Because human rights is something, as we said yesterday, that comes to the human being. Human beings have it. There's nobody who bestows human rights. You have it. And the duty of the state is to fulfill, to protect, to promote human rights. And this is very important, and it came back, I think, a number of times through our discussions also today, when we spoke about the way forward with respect to the challenges that are still there with respect to freedom of association and collective bargaining. At the end of the day, what we need to realize is that freedom of association, the right to organize, the right to bargain collectively, the right to strike, they are human rights. People have them. The ability to carry forward, to be able to defend, to be able to further, and here I quote from Convention 87, defend, but also further rights as well as interests, and the two are not the same. One is rather looking backwards, the other one is more looking forwards. In order for this to realize, there are many different ways, there are many different methods, and these are the questions that we ask ourselves and that we seek solutions for in building industrial relations systems. But the foundation is that all human beings, regardless of their employment status, regardless of questions whether they are employees, special categories of employment, precarious employed, part-time employed, irregular employed, all human beings have it. They have interests just on the basis of the fact that they engage in economic activity using primarily their labor. And that is what we, in looking these solutions and interpreting laws, that we always need to keep, I think, at the front of our minds. The forward-looking, and I had included some of the things in my presentation yesterday, and for reasons of time I didn't get there. But I think it is also important that when we speak about and when we seek, in particular cases, solutions for disputes around human rights, that we have a very clear understanding of what are the challenges that we are facing as a society, and that we are looking for solutions for within our constitutional order. And the challenges that we have, all of the countries, this is by no means exclusive to Korea. We've had the opportunity in the organization to look at it for a significant number of years, in fact, leading up to our centenary, which we celebrated in 2019. And there are three of those that I would perhaps very quickly like to touch on. One that is very often underestimated, but that has great significance also for the choices that we make in the international labor standards, not only that we ratify, but also that we use as recommendations, that we use as guidance, for example, when we have court decisions, is demographics. One of the biggest challenges for many countries in the world, underrated, is the change in demographics. And that establishes itself, displays itself in a range of areas. Many countries face the challenge of shrinking populations in the long term, aging populations in the short term, and probably what that means in the short term is making sure that a country makes the maximum use possible of the productive assets that it has. And here I come back again to the question of gender equality. Gender equality is probably promoting gender equality is probably one of the most significant interventions that can be made in any country in order to meet the challenges of demographics. Because as it shows, science shows, surveys show time and again, the academic achievement of women is very often higher than that of men. In order to make sure that labor markets, it's not just in terms of human rights, women being able to access labor markets, but it's also asking yourself the question, do labor markets need women? They do. They do. They need women for the labor markets of today. They need women for the labor markets of tomorrow. And in order to make that happen, you do need to look at issues such as equal pay. You do need to look at issues of how do we reconcile biological reproduction with job duties. How do we balance more equally family responsibilities? How do we make sure that workplaces in the large sense of the world are safe in terms of violence and harassment for women? So this is demographics, and I'm not exhausting it here by any point in time, but it brings in the importance of guidance you can find in international labor standards with respect to all of these issues that I just outlined. The other one, of course, is social security, and this is probably the other area that is a human right. It is established as a human right in the Universal Declaration. It is also codified in the Economic, Social and Cultural Rights. But it is an area in which the world has a very, very long way to go. The estimate is that 53% of people in the world do not have access to any, not a single one of the 9 social protection, social security areas that the ILO has identified in a convention that in fact goes back to 1952, the minimum standards on social security. Korea has not yet ratified it. We think it's obviously a very good idea to do so. It is actually recommended by our Executive Council for all member states to do so. Going forward, it will be more important than ever, not just to take care of aging populations, but also, and this is the second point, to meet another big challenge going forward, and that is the one that is posed by climate change. It is very likely that the imperatives of moving towards an environmentally sustainable society will require enormous changes in the industrial policy. There will have to be large-scale transitions from sunset industries to sunrise industries. It is very difficult, it will be very difficult to achieve that without at least two major mechanisms. One is social security, and the other one, of course, is social dialogue, because the choices that will have to be made in society are extremely big. And there, of course, we come back to freedom of association and collective bargaining, because without the guarantees for making sure that everyone who has an interest, who has a stake, can engage in social dialogue, there has to be full respect for freedom of association and collective bargaining, regardless of employment status. So demographics, climate change really are two of the major challenges. Globalization is another one. In the interest of time, I'll set that aside. I would like to conclude, though, with once again coming back to the question of Convention number 105 and the question on Korea's constitutional order. Convention number 105 is a convention that came about at the height of the Cold War. It was actually the direct outcome of a ILO, UN, again, you see the linkages, study on certain forms of forced labor that were practiced in countries around the world, many of them socialist systems. Some of them, though also, like my own country was involved in that study, Belgium, Australia, a number of other ones. Forms of forced labor that were state-sponsored is perhaps a big word, but that were particularly forthcoming from state action. And what was central in that idea was, again, to make sure that forced labor would not be used to undermine democracy and to undermine the key elements of democracy, which is, again, freedom of association, freedom of assembly, freedom of expression. There are ways of interpreting that convention in line with what is the action that needs to be taken in order to protect the democratic foundations of the state. I'm not going to go into the details, we don't have the time, but there is in my presentation a hyperlink to a very recent opinion of the Human Rights Committee that actually exactly makes that point and actually uses language that would be potentially very useful also in the efforts that Korea will want to make going forward towards ratifying that convention. But the essence of it is precisely that, is that freedom of association, freedom of assembly, freedom of expression, when it is used in order to undermine rather than strengthen the democratic constitutional order, restrictions are permitted, also under Convention number 105. So I will conclude with these remarks, but again, it's been a real pleasure, and we are looking forward to the next invitation from the Judiciary to support this important work going forward. Thank you.
네, 감사합니다.
Thank you very much.
그 말씀 중에서 특히 이번 컨퍼런스를 이렇게 겪으면서
So thank you very much for the comments. And then he also mentioned that the Korean, so you mentioned that one of the takeaways is that the Korean judiciary seems to be ready. And now the responsibility is upon us to show that your impression is right. Okay, thank you.
그래서
Next, let's go on to a presenter who talked about the relations with the domestic courts and the regional human rights courts. We will be listening to Dr. Kuntz. In Korea and in Asia, we have no human rights courts. And so in applying ILO conventions, what are some implications for Korea and this region?
Yes, thank you very much. I can only second the previous speaker. This was really an amazing experience, and I will leave here deeply impressed, and it was really enriching and very inspiring. It's true that I work on the regional human rights courts, but I hope nonetheless that my points were or are relevant also kind of in broader terms. I also permit myself to make two maybe kind of general concluding remarks in terms of by way of kind of the main takeaways. So I think for me what has become even more clear over these last 2 days is that we really live in an interconnected world, that the problems we are facing are really of a global nature. My previous speaker just has also spoken about the environment, for example, but of course also global security, the economy are really global issues. So really one of the main takeaways, I think, is that the role of the domestic judiciary has also, of course, become much more complex. It is not reduced anymore to just applying national law. Of course, international law, international standards have become very, very important. We have spoken several times also about the fact that enforcing international law is not always easy, it's not always obvious. Some obligations are not self-executing, for example, and maybe one of the takeaways or one of the conclusions of my research on the implementation of human rights standards through domestic courts in Europe and Latin America has been that the technique that courts very often use is the technique of consistent interpretation, kind of an indirect way of giving effect to international law, which has become a very often used tool. Which avoids or which helps courts to give effect to international standards, even if there is no implementing legislation in place. And actually, one of the results of my research has been that actually sometimes consistent interpretation is even more effective in a way, because very often domestic legislation comes too late or is too slow also in kind of reacting to ever-changing circumstances. So I really think consistent interpretation is a very powerful technique, a very important tool for domestic courts. Then I would very briefly like to say something also about challenges ahead. Yesterday we have talked a little bit about contestation. I have mentioned that I'm most familiar, of course, with the European context. We have witnessed an increasing number of cases of contestation against the European Court of Human Rights. The European Court of Human Rights has come under pressure, and what I find remarkable is that this pressure also comes actually from domestic courts that sometimes oppose or increasingly oppose also the European Court. The point that I have tried to make, or that I think is important, is that this is not necessarily always a backlash against the European Court of Human Rights. I think we also need to see that as kind of a reaction also against the power this court today has. And it's definitely also a question of judicial politics. But at the same time, I really think we should also not lose sight of the fact that human rights have come under pressure globally, also especially in Europe. We do face kind of an erosion of human rights protection. We have the problem of rule of law backsliding, but very importantly, also in my very own country, for example, Switzerland, we had debates over the last years, even the debate about exiting the European Convention of Human Rights, a similar debate in the United Kingdom taking place. Very importantly, there is a new Bill of Rights proposed right now in the United Kingdom that might risk to very severely restrict the effect of the European Convention of Human Rights. And here I really think courts have an extremely important role to play in upholding these standards. There is the debate now in the United Kingdom that even if this legislation enters into force, there is the hope, so to say, that domestic courts will nonetheless uphold the international standards. So I really do think domestic courts have a very important responsibility really in upholding, in securing these achievements, these standards of the last 50 years or so. Yes.
네, 감사합니다.
Thank you very much for your remarks. The topics that we are discussing today are global issues, and thank you for pointing out how interconnected we are. As a person who majors in labor laws, it is indeed a great pleasure to be able to have exchanges with labor law experts from abroad, and I feel a sense of togetherness because we are all deliberating over the same challenges. If we think about Europe, we always think how advanced Europe is in terms of human rights, but we can see that there is somewhat of a disturbance in the European system as well. So I hope that we can do our best in Korea so that we can have Europe benchmark us one day in the future. That's a dream that we could have.
And next is one of the panelists from Session 3, and it is Director Hwang from the Ministry of Employment and Labor. Thank you very much. So now, as we all know, for the 8 ILO fundamental conventions, we have now ratified 4. And then we have also made the commitment internationally to ratify even more. And actually, we have ratified 3 more in addition. So now they have also gone into effect in April this year. Now, given this backdrop, then the implications of the ILO fundamental conventions and then also some of the labor law issues that still remain. So this was a good opportunity for us to take a look back to the potential labor law issues and also to look ahead to the future challenges. So quite a meaningful conference, and I get the impression that I should have been here yesterday at the time allowed. And now, of course, despite the many different, let's say, controversies or debates, but the fact that Korea was able to fulfill its promise with the international community after around 30 years, so I believe that that in and of itself is highly meaningful. And for the ILO, now for the Korean government and also the employers and the worker groups, so the ILO, I understand, has also given a good appreciation of this result, saying that this is the result of the cooperation among the employers, workers, as well as the government. And then also regarding the recommendations given by the ILO so far, we also wanted to address them as early as possible. So for about 1 year, through social dialogue, we had discussed how we can legally streamline for these recommendations and where. So we have had such deliberations for over a year, and although we are not able to come up with a social consensus, but still, based on the discussions, we were able to improve upon some of the provisions in the Trade Union Act and the Civil Servant Act and so forth. So in this process, we try to stay in line with the spirit of the ILO fundamental conventions, while at the same time, of course, the different countries have their different specificities. So we also try to come up with ways to account for such Korea-specific circumstances in the course of the legal improvement. And in session 3, Ms. Curtis also mentioned that now for the fundamental conventions and also the ILO provisions, now they are not to create the same system or apply the same in all the countries, but this is to create the basic framework or the basic foundation. But then, of course, we have, I believe, although we have done that, but we still have a long way to go. So, for example, the number 105, as was just mentioned, then also for the ratified conventions, then we now have to submit annual reports and submit ourselves to the supervision. And also, given that we have ratified them, then we also need to further our efforts to faithfully comply with the provisions of the conventions. And despite the fact that we have made legal improvement, I see that there are still differences in terms of the evaluation of the efforts so far. Some saying that they are not enough, and I see that there are still differences in positions, especially between labor and management. So regarding specific issues, then the perspectives and the evaluation and the interpretations are bound to be different. I accept that, but we are not saying that since we ratified the conventions, that is it. So, of course, that is not the case. That actually opens up a lot more issues for us to discuss, to address, and the government will do so. We will certainly continue to address them together with the labor and management as well as the experts. And it is in these areas that we will continue to work hard, and of course you have our commitment, and we will continue to address these challenges and tasks. Thank you. Okay, thank you very much. So then now in session 4, Professor Sung-Uk Lee in his presentation mentioned that following the ILO convention ratification, then there are duties to the states. So for example, the duty to protect and respect and realize. So I hope that the government would also keep them in mind as well.
Next, we will go to Attorney Kim Yong-moon to talk about the overall conference. Well, rather than going into the overall conference, I would like to talk about some personal impressions. The contents that we dealt with today includes various policy changes as well as legislative action. And so it would have been great to see the Parliament participate in these sessions because they are the legislative body. Korea is well known for its rapid speed of change. I actually worked within the ILO for a year, around 2016. And within the ILO, whenever I talk to my colleagues, I have experienced that the labor laws of Korea and the labor protection of Korea is not far behind the international standards. And the ILO does not view Korea to be far behind standards. For the European countries, well, we do have very different backgrounds, but it's not about the European countries teaching the Korean situation. Well, if we take a look at the US, they have very low rates of ratifying ILO fundamental conventions, which is quite ironic. Related to legislation, I did not have time to talk about this, but the issue of subcontractors is a very severe issue in Korea. It's due to the dualization of the labor market, and I don't think it can be solved with just the courts, and it will lead to various controversies in the future. So we will need additional legislation for this issue. The last part that I would like to mention is related to what Judge Kim Dong-hyun has mentioned. What about the civil and criminal liability related to strikes? Well, if we take a look at the suits for damage compensation due to illegal strikes, when our law firm takes on these cases, we see that many of the courts actually take on an attitude that is very passive, and they try to avoid various issues at hand. For example, the speed of the judgment is very slow, and at times these disputes take very long to solve, actually more time than necessary, which leads to the disputes being prolonged for both sides. And so the ILO actually strives to find solutions through social dialogue rather than legal disputes. And so in such cases, maybe the courts can leverage mediation so that these disputes can be solved without prolonging legal procedures. Thank you very much. Thank you for your comments. Well, this is indeed a very important issue that calls for changes in our institutions, and also there is a need for new legislation. And so thank you for mentioning that it would have been great to have the Parliament join this discussion as well. So maybe the JPRI can take this into consideration for future conferences.
And now, researcher Erin Yoon, I believe that you didn't have enough time to say everything that you wanted to say, so it's, a few minutes past, but still, if you could now say what you wish. Now, the fact that we need to guarantee the freedom of association and the right to organize, regardless of the contractual status, is the obligation to the state. But still, when we look at the collective bargaining situation of Korea, then this is far from the duty. So that is the issue that I would like to comment on. Now, last summer, the Daewoo shipbuilding subcontracting union that had received quite a lot of attention. Now, there was the Daewoo shipbuilding, and then in this principal contractor shipyard, there were the subcontractor workers who worked together. And now, for the past 7 years, the payment to them was unilaterally cut. So for a few years, their wage was cut by close to 30%. So those with over 10 years of experience, their pay was now close to the minimum wage. Now, in order to move beyond the minimum wage, they wanted to have collective bargaining with the subcontractor, and the company would say that they have no collective bargaining rate. And these are all facts. So their pay was cut so much. So even the court also said that this is because the Daewoo shipbuilding had cut the payment to the subcontractor so much. So this is actually in violation of the Fair Trade Act. And also, the subcontracting company has little control over the employees, and it is actually the principal contractor that has de facto control over the employees. So this is all the findings from the Fair Trade Commission. So the subcontracting workers, now they're saying that they wanted to make improvement, they wanted to have collective bargaining, but then the subcontracting company said they had no right over this. So then they wanted to have the collective bargaining with the principal contractor, but then the principal contractor said that we are not your employer, we do not have to engage in bargaining. So then for close to 1 year, the workers were not able to engage in any bargaining, and the Ministry of Employment and Labor did nothing. And then now, as a last resort, the subcontracting workers went on a strike in the Daewoo shipbuilding shipyard, in the principal contractor's workplace. And also one of the workers created a 1 meter by 1 meter prison for himself on a vessel to create social interest. And then the president stepped in, saying that this is an unlawful strike and this is causing so much damages on the industry, and even they could use public authority to intervene. So the subcontracting workers had to put a stop to the strike despite not having resolved this. So since then the principal contractor is now claiming that they suffered damages because of the unlawful strike and has raised a suit for 47.6 billion won in damage compensation, and still trying to put a chokehold on the subcontracting workers. So again, the working conditions are de facto determined by the principal contractor. So the request was for the subcontracting workers to be able to engage in bargaining with the principal contractor who had the de facto control on their working conditions. And they wanted to have this legal amendment. But then upon this request, what they would say is that then this is going to shake the entire system of the Trade Union Act, and they might be liable to these, and also this could put the principal contractor to legal liability. But I believe that this is a big misunderstanding. So even if we recognize him as the employer, the obligation to engage in collective bargaining does not mean that they have to accept all the terms, all the demands of the union. And it is not also compelling them to sign a collective bargaining agreement. It simply imposes them the duty to engage faithfully in the collective bargaining, meaning that the employer, in the course of the collective bargaining, if there are terms that are demanded that they cannot accept, then they can refuse to accept them. And also even at the Central Labor Relations Committee, and now they also have decisions saying that the principal contractor is also subject to the collective bargaining. And it is the same situation. So in other words, the principal contractor should engage in the collective bargaining where they have the direct control. So this is to create something like a safety mechanism for the employer as well. And for the employer, so if they refuse to engage in collective bargaining, does not immediately subject them to penalties. As I mentioned earlier, by practices, but there have been very few cases where the refusal to engage in collective bargaining went directly to legal penalties. And then also for the court's judgment that has been finalized, then in this case, so for the court's final judgment, they were penalized afterwards because they had repeatedly refused to accept the court's decision. So that is why they were punished, not because they refused to engage in the collective bargaining. So now let's say in this case, they are not legally the employer under the law, but now they are demanding collective bargaining from this employer that is not legally an employer, and then they go on a strike asking for such collective bargaining, and now automatically this is seen as unlawful strike, and then now even when there was no violence or destruction of the property, and so they were then subject to penalty, and now they were threatened with public force as well. Again, this comes down to the fact that there is such narrow definition of the employer, and you see that the negative consequences of this are going to the workers. And what the ILO recommends is not something different now for the subcontracting workers. Now they need to be able to engage with the principal contractor so that they will be able to improve their actual working conditions. But to just brand them as illegal and then subject them to criminal liability or penalties. So the ILO's recommendation is to refrain from such legal application that would subject them to penal liability. So I believe that understanding the current situation in Korea as well as the circumstances, I hope that the judges and the courts will be able to make their interpretation in line with such recommendation and the conventions as well.
Presiding Judge Kim, do you have any additional comments? No? This brings us to the end of the discussions by the designated panelists, and I do believe now it's time to open the floor for comments and questions. Not only will we be accepting questions from those who are participating on site, but we will also receive questions through our YouTube channel. You may ask a question to a specific panelist, or you can ask the whole panel a certain question. If you wish to make comments, comments are also welcome. We will now open the floor for comments and questions. I am Yuson Hee, a journalist from Gyeongyang Daily. I have two questions. Well, we talked about Convention 105, which is not ratified by Korea yet. As you're well aware, ever since the strike by the cargo trade union, there was the go back to work order, and ILO has made a statement, but additionally there was the additional back to work order. And this is related to Convention number 25 as well. And so could you comment on the back to work order issued by the Korean government to the cargo trade union? The Fair Trade Association of Korea actually is not recognizing the members of the cargo trade union as workers. They are saying that they are self-employed. And so I would like to ask the ILO perspective concerning this. Well, maybe we can take a round of questions before we answer. So we will take the next question.
Hello, I am Kim Hyun-jung, journalist from the Catholic Peace broadcast. Thank you very much for your talks. Now, Judge Kim, and also researcher Yoon mentioned something similar, and that is about the damage claims and also the calculation of the damages. So now in the 1987 Constitution, now when the three labor rights came in, the right to collective action, And then now arising from this is now when the workers go into a strike, then there would be the ordinary damages. So for example, the losses that may be incurred from the stoppage of work. So for such ordinary damages or the ordinary losses, they should be simply accepted by the employer for these basic rights to be effective. And it is something that is in addition or incremental to that we can hold them liable for. I believe that that would be in line with the spirit of the Constitution. And also regarding the back to work order. Now, our Constitution also clearly forbids forced labor. Now, the truckers, if they are not employees or if they are not workers, then of course that they would not be subject to forced work, but then this would still be interference of their business. So again, the back to work order, do you not believe that this is against the Korean Constitution as well?
Well, it seems that many journalists are very much interested in this conference. Thank you very much for your interest. Are there any other questions from the floor? I am from the Seoul High Court. I have a different perspective. Well, this is a question to Senior Advisor Tim DeMeyer. I did prepare my question in English.
Supreme Court Justice Kim and the distinguished panelists. I am Seoul High Court Judge Jung Junyoung. I have a question for Senior Advisor Tim DeMeyer. You have devoted to promote the social dialogue with employers and workers in many reasons. I admire your efforts and passion. As you know, the ILO Fundamental Conventions on the Right to Organize, which were ratified last year and are effective this year in Korea, declare that the employers as well as the workers have the right to organize, particularly the right to organize and collective bargaining convention of 1949 says the workers and employers organizations shall enjoy adequate protection against any act of interference by each other. Workers' organizations, generally called trade union, have been recognized and expanded by Korean legislations and court decisions. But even though the employers' organization scheme was introduced in the Korean labor law in 1963, it has not yet materialized technically and even practically in the labor law context. Instead, the government authority often has become the counterpart of the nationally organized or industry-level trade unions in Korea. As far as I know, the employers' organizations are well established in many European countries. So, Tim, let us know the world trend and the good practices of the employers' organizations from the perspective of the ILO Fundamental Conventions. Thank you.
네, 안녕하십니까. 사법정책연구원.
Hello, I am Tanbi Lee, in charge of French law research at DJPRI. Let me first say that it was a great learning experience for me at this conference. But then now, I do not have much knowledge in the domestic labor law, so I am not capable of providing such sophisticated question. But as a general member of the public, I just thought of a question. Now then, Judge Kim talked about the unlawful or the lawful industrial actions and also the border between the two. So for example, the workers started out something that thought was lawful industrial action. But then you also mentioned that the boundary of the unlawful industrial action is broader than they might think. So it would be one way to reduce the boundary of the unlawful industrial action. So then my question is, can you be more specific? So can you give some examples of what are the lawful or the unlawful industrial actions? Okay, thank you very much. Then we have received questions from 4 members in the audience. So why don't we listen to the responses first before we move on to the second round. Then I would like to first go to Judge Kim to respond to the question, especially about the damage calculation and also the scope of lawful and the unlawful industrial actions.
Well, first of all, the question from the Catholic Peace Broadcasting and the researcher just now, I think the two questions are connected, so let me answer them together. If we take a look at the Constitution, it is true that it actually protects the right to association, and therefore compensation for damages due to the right to association, such as lawful strikes, cannot be issued. But for illegal strikes, it is true that there is legal and criminal liability. And if we take a look at the scope of illegal strikes, the scope is quite wide. As researcher Lee has asked, what is actually the scope of illegal strikes? For example, as Professor Lee has mentioned, let's say that there is a strike against a management issue. That is a strike that is prohibited by the Supreme Court. One of the judgments that is most criticized is strike against the mass firing of the laborers, especially related to massive layoffs. So if there is a massive layoff, unions have the need to protect their members against the layoff through strikes. But currently, a layoff is not a reason for legal strikes. And it's very difficult to have subcontractors participate in collective bargaining against the main contractor. And so if there is a strike by subcontract workers, it would be deemed illegitimate by the courts. If we take a look at the international labor standards of the ILO, all of the political strikes to enhance the socioeconomic position of workers is recognized. But I do believe that the Supreme Court does not even recognize strikes on those grounds as well. And so the exercise of the right of association is usually done with an urgent issue at hand, but if they are deemed illegal, which then translates into civil and critical liability, that is our current reality. I don't know who asked this question, but I think it was by researcher Lee. So what is the boundary between legitimate and illegitimate strikes? Sometimes unions may start a strike because they believe that it's legitimate, but they find that they find themselves amidst illegal strikes, and that really is a pain point within our labor system. If we take a look at the Criminal Act, this actually goes against the concept of clear stipulation. And so we have to take a look at the subject or the goal of strikes. And so depending on the goal of strike, that actually is the deciding point in deciding whether the strike is illegal or not. But deliberating on this goal is very difficult. So from the trade union perspective, when they engage in industrial action, they're never really sure if it will be recognized as legitimate or illegitimate in the initial stages of their industrial action. And those type of industrial action deemed illegal later on are then found criminally liable. And so I think the criminal act related to labor actually is not clear. So within the Labor Act, we need to, in principle, exclude criminal punishment, but we need to induce compliance through administrative action. The back to work order is another question that was raised. I do believe that that dispute will come back to the courts, and so it's very difficult for me to comment as a presiding judge at this moment. I am not an expert in the Fair Trade Act, but if I may just offer you a rough impression, the Fair Trade Act is to protect the market against monopoly by those with strong market power. That's the impression that I have, although I'm not an expert. But if we take a look at the truck drivers and the action by the truck drivers, if that actually is deemed to be a disruption in the market order, I don't know if this is in line with the basic concept of the Fair Trade Act, saying that they are self-employed, but at the same time limiting their rights to work through the back-to-work order is quite contradictory. If they are workers, they have to be protected. If they are self-employed, then they need to have the freedom to run their business as they seem fit. But it seems that they are not benefiting from either position at this point in time. And so as someone who is not an expert in this area, I'm just offering my impression. But I think there are contradictions involved. This is not an official opinion of the courts. It's just a personal impression that I have. Thank you.
And yes, there were two questions to Mr. Tim Demeyer.
Thank you for these quite pertinent questions, of course. As regards Convention number 105, the text of the convention is clear. Immediate abolition of any form of abolition and suppression of any form of forced labor as a means of participation in strike action. It being understood, strike action that is to be considered lawful in connection with international labor standards, and these are, of course, the ones that have been elaborated in the context of cases brought before the Committee on Freedom of Association, as well as the comments that have been issued by other ILO supervisory bodies, first and foremost the Committee of Experts on the Application of Conventions and Recommendations. So all of that set of commentary is important in understanding what a lawful strike action is, also in the context of Convention 105. And the other aspect, of course, being that the strike action needs to be peaceful. So any act of violence, incitement to violence, preparatory act of violence would not enjoy the protection of the convention. Now, obviously, Korea has not yet ratified that convention, and the implication of that is that the convention at this point in time, de facto, legally speaking, serves as a recommendation. Quite an authoritative recommendation, given that it gives expression to an ILO fundamental principle and right at work in the Constitution, but legally speaking, a recommendation at this point in time. So that is therefore Convention number 87, and there are plenty of examples, and you can look it up. I mean, this is in the public domain. There are a good number of examples where back-to-work orders have been considered in the context of the application of Convention 105 for those countries that have ratified it. The second question with respect to the Free Trade Commission and their assessment that certain categories of workers, particularly in the special employment category, are to be considered as business associations. It's a complex question. Just like Judge Kim, I am not a specialist on competition law. The Fair Trade Commission would be a commission that is responsible for the enforcement of competition law, protection of competition, and that means in the context, first and foremost, protection against antitrust. So the consideration there would be, and I go back to something that was presented earlier by Ms. Curtis, whether a worker is considered an employee or not an employee is in and by itself, or should in and by itself not give rise to a distinction as to whether the principles of freedom of association and collective bargaining apply. Which is another way of saying that if the category of self-employed is recognized in the legal system, as it seems to be the case, then that is in principle something that under ILO standards we would recognize, given that one of our standards also says there is free choice of employment. That arises from Convention number 122, which Korea has also ratified. In the context of human rights, in the context of the right to work, we do recognize the free choice of employment. But it's not because somebody is self-employment that as a result of that, as a result of the competition, the application of competition law, that would then have the result that freedom of association and collective bargaining rights are taken away. Now, if I operationalize this a little bit, that means that in order to realize, and I think that's an important point that Ms. Curtis made, there are various ways, various means of achieving the realization of collective bargaining rights. And it does not necessarily imply that you need to take away the categorization of self-employed. It does not necessarily mean that. You could, through an interpretation of competition law, reach a conclusion whereby the self-employed have an ability to collectively try and improve their terms and conditions of, let's not call it unemployment, but their terms and conditions of work by negotiating with those that have the power to determine, that have the, particularly first and foremost, the financial power, the economic power to determine those conditions. And this is something that we have seen fairly recently happen. There's a number of examples in the European context. Ireland is one of them, I think about. And for research purposes, I would actually very much encourage you to take a close look at the guidelines that the European Commission just put out in September of this year. The guidelines with respect in the context of competition, the EU competition law, the guidelines they put out in order to, if you wish, create a space within competition for realizing collective bargaining rights for persons for whom the employment status is not clearly determined. And that would include also what you call the special employment categories. And it is interesting, and it is fairly complex. It is interesting because it deals with a number of fairly detailed questions. Because it would not be automatic that any type of agreement that the self-employed conclude either amongst them or with those who determine their terms and conditions of employment would automatically be exempted from anti-competition law. So you really need to look at the details. Now this is a preparatory stage for EU legislation. Down the line we will see and hear more of it, but the guidelines in itself are already very very important topic for further study. So, to summarize the answers to the question, the very legitimate question that you're asking, it is one thing to consider collective action by self-employed as a business association. Fair, possible, maybe, but it should not automatically mean that when they undertake action collectively with a view to improving their working conditions, that is necessarily a cartel, that necessarily comes under the antitrust legislation or legislation for the protection of competition. There has to be a space eked out there in order to make collective bargaining possible. Maybe the last point on the question of lawful strike action. Fortunately, we have now the benefit of the availability of the compilation on freedom of association principles in Korean, and I would very much refer you there for details. Very much in summarized form, the way we've traditionally, from an international legal perspective, we've looked at this, is to say, well, any type of collective action that is taken on the basis of trade union freely organizing their activities with a view to defending and furthering the interests of workers, in principle is protected. That means in principle should be lawful. And there is, based on that principle, there are then a number of exceptions that are considered necessary in order to balance it with other very significant interests, the life, safety and health of the population, major disruptions, long-standing disruptions to the economy, protection of safety and health, and certain categories of workers that provide services that are directly related to the security of the state. These are, by and large, the very large categories for which there are then exceptions. But this is more or less the frame around which we would consider the question of legality. Thank you.
정준영 판사께서 질문하신 건?
Well, concerning the question by Judge Chung, well, could you talk about any employer groups that are existing in Europe that was asked by Judge Chung? Judge Chung did ask a question related to that, in whether there are any cases in ILO or Europe that is related to employer groups. Do you remember?
Overlooked your question. It was not deliberate. So, in principle, it's clear, and Article 2 of Convention 87 is clear to that respect, that the protections with respect to the right to organize apply to workers as well as employers. And there are a number of cases, obviously not as numerous as for workers, where the supervisory bodies will make comments. And I say the supervisory bodies in more extensively, it's not only the Committee of Experts, but will they make comments with respect to restrictions that have been imposed on employers' organizations. And I think off the top of my head, and Karen will definitely have a far more extensive knowledge of this, but I think first and foremost about a case that is still under consideration also by the ILO's Executive Council, the governing body, the question of Venezuela, where there have been restrictions on employers' organizations, both with respect to their right to organize as well as their right to engage in tripartite consultation, which would then come under Convention number 144. So yes, that there's a good number of examples, and if there is a desire, then we can identify those as you see fit. We can follow this up on offline. Thank you.
네, 답변 감사합니다.
Thank you for your answer.
예정된 시간은
Well, we are behind schedule already, but if there are any urgent comments or questions from the floor or the panel, we will provide you with that opportunity.
플로어 없으십니까? 혹시
Are there any additional comments from the panel?
뭘 오셨는데 한번.
Maybe one extra comment, and I want to go back there to the question of contestation that Rafaela was bringing up yesterday. I think we do see worldwide a trend that would resonate with the contestation that was described yesterday. We would see worldwide a trend whereby the human rights as they are determined at a level above the national level are increasingly asked in question. And I think this goes back to a broader trend whereby people collectively at the national level, but in fact not just at the national level, at a local level, regional as well as community, where there is increasing attention and increasing questions asked around questions of identity. We see that throughout life in society, and I think that can lead to a situation where also what we then describe as an erosion of the social contract, what we sometimes describe in the jargon as a restriction of, not a restriction, but a shrinking of the civic space. I think this is a dangerous development because, as I said earlier, some of the challenges that we will need to meet, including through normative means, over the medium and the long term, I refer to demographics, I refer to social security, I refer to the decisions that will come in the context of climate change. That is difficult because a lot of these challenges will have to be answered at the level above the local, the regional, and even the national. Solutions eventually will need to be developed, elaborated at the national level, but a lot of the challenges are transnational in nature, and there needs to be an understanding, there needs to be an agreement, there needs to be cooperation established at the multilateral level, and this is why you do see the UN Secretary General calling for a new social contract, where you see the ILO Director General very much in consonance with that, calling for a global social justice coalition. It's not being global for the sake of global, but it's really realizing that it will be very difficult to meet those challenges if there is not a common understanding, and that is rooted in the human rights that, as I said earlier, that are not bestowed necessarily by the international treaties, but that are inherent in the way that human beings are. So what you see there is part of a broader pattern that we need to be responsive to, but at the same time also need to be aware that if it is taken too far, that we will come to a sort of paralysis that will not enable us to meet the challenges that we have to meet. Thank you.
예, 그러면 종합 토론.
Thank you very much. I think we are able to close the final plenary session at this point in time. We have had discussions throughout the last 2 days, and we have taken a look at the current status, some of our tasks at hand. And we have also had opportunities to talk about how ready domestic courts are in Korea. I think we can be more confident in taking the next step forward. Thank you very much for your participation from home and abroad, despite your busy schedules. Thank you very much once again. This brings us to the end of the 2022 Judicial Policy Research Institute International Conference final plenary session. Thank you very much.
Yes, thank you very much. I appreciate all participants of the final plenary session for actively sharing your insights and opinions. We are now coming to the end of this two-day conference. I believe we have achieved significant progress in seeking the desirable direction for domestic implementations in international human rights law and labor law through in-depth discussion by legal experts from home and abroad. It was my great honor and pleasure to be a master of today's conference. On behalf of JPRI, I would like to extend my sincere gratitude to moderators, speakers, and panelists for their valuable contributions based on their expertise. And I appreciate to all participants who have attended this conference, both online and offline. Also, my special thanks go to the staff members and interpreters who have been working so hard to put this conference together. Let us give a big round of applause to all participants. This concludes 2022 JPRI International Conference. Thank you very much.